In view of the reasons stated above, this court is of the view that this court does not have the jurisdiction to act upon the application. Liberty is given to approach the Bombay High Court.
May I please interrupt? Another new case for listing on Friday.
Huh?
New case for listing on Friday.
Regarding what?
Another
Regarding what?
settlement of market money. Yes, I don't matter today. Maybe partnership tomorrow.
What is the urgency?
Urgency is there, my lord. Agreement has been cancelled.
Huh?
Railway has cancelled agreement with me, and prior to its cancellation of the agreement, another tender has been processed on the same one.
So when is the last date?
Fourth day, my lord, tender.
Huh?
Fourth day is a tender opening and closing.
When? 4th of March.
4th of March. Order,
Never tomorrow.
my lord, I will have to get the.
No hurry.
If your lordship has a fashion order.
If you don't get anything,
My lord, tomorrow, my
Fourth.
I'll try, my lord. I'll try, my lord. May I please? Then my
I said 4th.
Friday. Okay.
I said yes, Friday.
Okay.
Friday.
May I please, Lord? With regard to item number 24, Lordship has asked to mention the matter taken up at 2.
Sure, tomorrow, nothing to be discussed. Nothing to be.
Item number 24 may be upgraded at 2 p.m. Lordship
Item number?
24 may be taken up at 2, Lordship. But Lordship has asked
Item number 24.
the tender method, Lordship. There is- Okay, so at 2. On the 8 digit, Lordship. Okay, concept of the other side, method, I can mention item number 18. If it is case, my lord, I have supposed to have 18. I have corrected the document. So, my lord, then that may be taken up next Tuesday method. The meantime, I will type my 18. Well,
On the prayer for adjournment made by Mr. S. Hoff, which is not objected to by Mr. S. Bora, is the matter after?
next week.
Is the matter after the?
Okay. Okay, please, madam. We will consider the additional application item number 12. We seek some time for the final return.
Have you taken the consent of the other side?
I'm appealing for explain what to see.
Okay, so no objection. Mr.
Be that, my lord.
Pida, Learned Counsel for the petitioner, submits that he has taken the consent of the other side and pays for
My lord, 2 weeks.
2 weeks time to file affidavit in reply.
Rejoin.
Uh, Mr.
D. Bora.
D. Bora,
D. Bora.
appearing for
IOC.
appearing for IOC, submits that he has got no objection to the case. According to this matter after the
Well, I pay for 6 days, my lord. Since the senior counsel is preparing. Preparing.
You are not in a hurry. If you are in a hurry, you take 1 week, you take 2 weeks. No hurry. Yes.
Please, your lordship, with you consent of the other side, I beg to mention item number 7 of the daily.
Item 7.
7. I'm making this mention on behalf of Mr. B. Council, Mr. B.
Wait, this is a LPG matter, Mr. Bora, D. Bora. This is the LPG matter. LPG matter, correct? That NIT. Regarding, so this is quite an important matter, I think.
We will go into the timeline. Yes,
Give it.
I speak for
Give it. Very important.
Please, your lordship. I beg to mention item 2. Lordship, we got the relief. This matter can be discussed.
Item 2.
Yes, Lord.
Okay, Miss
And Becca.
N. Deka, Learned Counsel, appearing on behalf of
A. Samua.
A. Chamua, Learned Counsel for the petitioner, says that he may be allowed to withdraw the petition as the relief sought for has already been granted. The prayer of the Miss, yeah, for the other side.
No, my lord.
Miss, the prayer of the petitioner's counsel is allowed. His petition business has been completed.
My lord, with you consider the other side, I beg to mention item number 7 of the daily.
Yes,
My lord, I'm making this mention of behalf of Deputy Council, Mr. B. Gogol.
what do you want?
May I pray for 2 weeks time, my lord?
For what? 2 weeks time for what?
My lord, to file an application.
2 weeks time for adjournment or what? 2 weeks time for adjournment?
No, my lord. My lord, to file an application, my lord.
Okay, have you taken the consent of the other side?
Understood, my lord.
Mr.
H. Bolo.
H. Baro appearing on behalf of
The P. Gogol.
B. Gogoi, then counsel for the PWD. Is granted 2 weeks time to file affidavit in the police. This is the matter.
Tell your objection.
My lord, this is a contempt matter, my lord. It may be discussed on Friday night.
It's a pending matter.
Pending matter after
Next week, madam.
notice is for it has
Yeah.
not been made.
Tick.
Next
No
month.
hurry.
May I please? I beg to mention item number 6. Item number 6, my
Yes,
senior counsel Mr. Sahiwala because of personal difficulty is not applicable. I have taken the consent from present.
yes, stood for the other side.
I am for that. All ready.
No hurry. No, so any affidavit, are you filing any affidavit?
Buildings are already completed.
It is a complete.
Ma'am.
No work order issued.
No, my lord, the non-payment of contractual.
Yes, correct. When you work without being issued any work order, you work at your own risk, it appears.
That, my lord, the work has been executed by the rest.
What has been-
Execution.
Okay, right. Mr. On the prayer for adjournment made on behalf of Mr. G. N. Sahewala. This is the matter. In the next week.
Ma'am.
The issue here is with regard to non-payment of dues claimed by the petitioner. On the other hand, the respondent cases that no work order was issued to the petitioner.
Much.
My lord, exhibit that.
17. Yes,
Also, my lord, documents of complexes deal. Have no instruction on the whole pending whether of the parent begin of other there to be go. But the instruction to the bank, whether he has got some.
okay, right. Mr. I. H. Shaikia, learned counsel for the petitioner, says for time to obtain instructions as to whether the matter has become instructive, or whether the relief claim has been paid to the petition. This is the matter. Let's go next week, Tuesday.
Obligation. I will deal for the lordship granted for four. Lordship permitted to be listed on 4. May I pay on 1st of 5.
Which item?
Which I for unlisted I filed together
You wanted when?
on 1st of March, Friday.
We give you first only. Friday.
Obligation. May I please, Lord, I beg to mention for listing of the repetition of next week, my lord, is matter regarding non-payment of contextual bill, my lord, the pending matter. And
No hurry.
my lord,
No.
the returnable date was over, on-
Mr. Counsel, that contract was for which period?
my lord, it was extended time to time, my lord, only
Which period?
till, my lord, it was extended January.
No hurry, Mr. Counsel.
Obligation.
Lordship, would you kindly allow this matter to be taken up a little later by senior is currently in court number 1.
Mr. Chaudhary, yesterday's matter.
Yes.
Out there, you all did not take part in the interview, correct?
Yes, because we are prevented.
You took part in the written examination. So
No,
the,
only interview.
no, there was a written examination.
Whatever is the.
No, just
segment
find
of
out.
test.
I think in the pleadings, you'll have said because there was a
Initially,
preliminary
no, Malak, initially there was a screening.
screening,
In that screening, we were permitted.
correct. Thereafter, you were given admit card.
Thereafter, they stopped us from participating in this election process.
Are you
Sit
sure? But in one repetition, I found that you have said that you are given admit card,
Yes,
Then you
that's it.
admit card, and then you are allowed to take part in the examination. That is there in the pleading.
In my case,
5535 or something. No?
yes, yes.
And thereafter, thereafter they said that you were not allowed to take part in the
Because we
interview.
do not have the prescribed
Requisite
qualification.
qualification. So I just wanted to clarify.
Yes.
Whether you took part in the written test or in the interview or in the subsequent,
My lord,
just find out
can I
that.
get back after
Yes,
half an
yes.
hour, my lord?
Because
Or
my,
maybe at 2 o'clock,
anytime.
or
It's just,
maybe little earlier also if I
Because
allow my
I-
junior to get that in.
the facts have to be clear.
Yes,
Only that.
yes. After some time.
This is it.
Okay, my lord, item 20 and 21, my lord. Out of the same tender, my lord, but work is different. Okay, my lord, in item number 20, my lord. Pursuant to the tender notice dated, my lord, 23/12/2023, my lord, I participated in the said tender process, my lord, and thereafter, my lord, the petitioner and two others, my lord.
Huh?
Thereafter, my lord, the petitioner and two others were, my lord, technically, my lord, qualified, my lord. And my lord, financial bid has been opened, and in the financial bid, my lord, the bid offered by the petitioner was considered as a L1 bidder. And thereafter, my lord, abruptly, my lord, a letter has been issued, my lord, cancelling the entire tender.
Where is that letter? Where is that letter cancelling the entire?
Cancelling letter, my lord, page 25. Page 25, my lord. And bottom line, my lord, the instant bidding process is being annulled due to technical reason and fresh bid shall be invited shortly. And accordingly, my lord, on the same date, my lord, page 26, my lord, fresh NIT has been issued, my lord, for the same work, my lord, under same estimated cost, my lord, same duration, and my lord, same bid security. And the last date for submission of tender is, my lord, tomorrow. I'm agreed by this, my lord, cancel.
Yes, what is this?
Already that annulment of the tender process has been due to some technical reason.
What is the technical reason?
It's not that I have to file activity. One thing is
You have
there.
to file and then we stop the entire process.
No, lots of one thing is there. As for the NIT, the condition that clause 30, the employer's right to accept any bid and to reject any or all bid.
Correct, but this is your reason is the technical reason. It's not for
Technical reason.
yeah. What is the
Lordship, the
technical
employee
reason? You
taken-
clarify.
No, Lordship, what happened? He can participate in the first tender law.
I think that
Today is the last date, Lordship.
maybe
Today he can participate.
if
So
he,
how he is prejudiced, Lordship? He is not prejudiced
why not?
because
Why not?
uh,
Once you have opened the tender,
Lordship. Yes.
and once you have he has found out that he's the lowest tenderer, he is expecting that the tender should be given to him. Now, why you have suddenly said that you'll have a fresh tender?
They have got,
Technical reason has to be explained.
because they have the department has unofficially got some complaint. That's why they have cancelled the tender.
That has to be reflected.
So,
by the-
Lordship, he can today itself he can.
That's
right.
how that will give him the option, but that does not bar. That we cannot allow.
But the employee's right to accept and the reject the all these.
Third, Mr.
K. Burwa.
K. Barwa. K. Barwa.
K. Burwa.
K. Barwa, another counsel for the petition, will submit that the petitioner has participated in the
Is the tender process.
NIT dated
Lordship,
23/26 for maintenance of road. Maintenance of road. So, the petitioner, so it was a two-bid system,
Lordship,
two-bid or one single bid,
Chairman, technical bid and financial bid.
so two-bid system. The petitioner was found to be the lowest tenderer after opening the technical bid and financial bid
That certificate.
of the
was
tenderer.
lordship.
Full stop. Next. However, the NIT dated 23/12/23 was cancelled by letter dated 17/2/2024, which stated that the bidding process was annulled due to technical reasons and fresh bid would be re-invited shortly. However, on the same day itself, that is 17/2/2024, another NIT dated, another NIT was issued, wherein the financial bits were to be opened, or when the technical bits were to be opened on 28 to 2020. Next, the petition council submit that no clear reasons have been given as to why the earlier tender process has been annulled, except by stating that it was done due to technical reasons. Next paragraph. Miss
Arbor,
R.
Arbora,
Arbora, Mrs. Arbora, Leonard Council appearing for
for all the respondents.
all the respondents. Submit that in terms of,
One second.
where is that?
They have not annexed, I have the copy of.
Why have you not annexed?
Yes.
Why you
they have
trying to
not
hide
annexed.
things? No, anyway, give me that.
I have an exam tender matter.
No, the employees right to accept any bid at any time. So
Otherwise,
we go to
Page 15, I have an exam, NIT matter, that page was-
30.
Huh?
30.
That this page is missing.
that page, my lord, I was not supplied, my lord, but.
You are not supplied.
But if
That's
no,
the
there's
time-
no way- there's a-
This is your tender notice with the council. There are, you see, don't insult your own intelligence.
Paragraph 30, Lord.
Right, Ms. Spencer, council for the petition, for the response subject said. The employer has the right to accept any bid or reject any or all bids in terms of clause 30 of the NIT, dated 23 February. Wait, sir. The right to accept any bid or reject any or all bids. In terms of clause
30.1. 30.1.
the NIT, dated February. So will you produce the report?
Lordship, I'll produce the record.
When?
Why they have rejected on technical ground, I'll explain, for filing an affidavit. This is regarding construction of the road, Lordship. That's
No,
what
no,
I
whatever, I'm saying this.
Because they have hurried.
I'm saying this, madam. So when do you want? When can you
So
bring?
Lordship, may kindly give us short time, Lord.
When do you want?
Okay.
You tell me when can you bring?
Today. Next week, Lord. March 5th.
Fifth is Tuesday. Then this is the matter on fifth, on which. Okay, we listed on, fourth, sixth. This is the matter on sixth, on which date? The correspondence council shall produce the report.
Lord.
Till the next date. The status quo shall be maintained in respect of the NIT dated 17 to 2020. Bullet.
Same order, in respect to item.
Same order next one. Actually, one thing is, we have said that he was L1, no lowest tender. Same order next page. Alright,
Public.
Look, my learned friend was supposed to obtain the instruction.
have you given him a copy?
My lord, will kindly have a look at the last sentence.
Hmm.
Sorry. ADC Borpeta, the Board of Directors on 28/7/22 has taken a resolution for reassessment of revenue, and reassessment of revenue is already done and then to be placed in the next BOD meeting for approval. If reassessment is done, naturally my revenue, my dues will come down. Well, they are
What is
projecting
this
only
letter?
one
What is
side.
this letter? Dated? What date? What is this letter dated? Which year?
26 to 2024. Yesterday, lord. 26.
Okay, what about this? In compliance of the report of ADC Barpeta, the board of directors taking the for the assessment. Where is this?
There is erosion of that river lordship.
This last sentence.
Yes,
It says
in
that
compliance.
the board of directors has taken a resolution for reassessment of the revenue. And reassessment of revenue is already done.
Yeah.
So where is this reassessment of revenue that has been done?
The assessment is done. It's not, yes, it is not procured, Lord. I have not taken that reassessment.
That is what we want.
No, that part I can bring, Lord. That reassessment is already, here, Lordship, that part is a, here reassessment and BOD decision is a separate thing. And yes, as because he has not paid, so we have cancelled. And that part, if
There is one thing you have not paid the earlier part.
so, my lord, if they deserve.
My learned friend, he cannot behave like an ostrich, my lord. He knows everything, yet he will selectively. What
No,
is the
no,
case?
we'll return it. If something, if he deserves it, we are very much.
No, you have
sincere,
already
Lordship.
taken. My lord, kindly see the last order. Please have a look at the last order. It is the further case of the petitioner, para 4, my lord. It is the further case of the petitioner that petitioner has filed a representation before the authority, on the basis of which certain inquiries were made and report has also been submitted. A specific stand has been taken in the board meeting of the corporation held on 28/7/22. A decision was also taken to reflect the revenue in the aforesaid backdrop. Accordingly, Sri so in the aforesaid submit that petitioner is still willing to pay an amount of 5 lakhs immediately, and he will continue pay the revenue after reflection as proposed, and therefore, during pendency of such exercise, Mahal should not be put into sale. One. My lord, if your lordship will kindly come to page number.
Just a minute. We have something else.
My lord, I could not pay the revenue because the fishery was, my lord, eroded because of siltation and all. Therefore, they themselves took a decision to refix the revenue. The benefit of refixation should be given to me, not to cancel the lease. Sorry, my lease. Please come to page, my lord, 61. This is the communication from Office of the Deputy Commissioner to the Managing Director. It was on 21/1/22. With reference to the subject and communication cited above, I have the honor to inform you that on receipt of your letter mentioned under reference, the Circle Officer, Baghbor Revenue Circle, was requested to conduct an inquiry on the erosion of Silosi bill connected with River Brahmaputra falling under jurisdiction of Baghbor Revenue Circle of Barpeta District, and to submit a detailed assessment report with all supporting documents to the Zen White Office later dated Wednesday. Subsequently, the Circle Officer, Baghbor Revenue Circle, has inquired into the matter and submitted the inquiry report on assessment on erosion and siltation of fishery land of Silosi bill, along with detailed report of the Mondal press map Sita copy showing the eroded and silted portion of the fishery of the land of Silosi bill, details of which is as follows. Kindly see, my lord, total fishery land as per record is 99 biga, 40 biga eroded by River Brahmaputra, and 20 biga silted by sand. Then next one, my lord, 200 biga, then almost silted by sand and mud. So, my lord, if I cannot fish, if I cannot operate, how do I pay the revenue? That's why, my lord, once they cancel it, then they restore the settlement earlier. Then they took a decision that they will refix it. So let them refix it, my lord. I'm prepared to pay some amount, 5 lakhs.
So both these fisheries are
Are-
settled with you.
Are the subject matter, yes.
Still in the vernacular, I'm not giving it, Lord. I can give it. Here,
You
yes,
to-
he has stated in statement by writing that he cannot pay the amount, Lord.
No, he cannot pay.
Yeah, Lord's last part I'm mentioning. Cost of I cannot, as per the settlement, I cannot pay the revenue. Here he has said,
Pay the revenue for which period?
any amount. Now I have to pay 31,28,651 rupees. I am not being able to pay that amount. He has written it in
So this 31 lakh,
Yes.
27,000
28,000.
is for which period?
Entire
For the,
period.
for the very beginning.
Entire period, yeah.
He has not paid, Lord.
So, my lord,
So he has stated specifically that he cannot pay in the statement. I can pay, I can give it in a affidavit also, Lord, because Lordship has given, asked me to instruction, so I'm not being able to translate it.
But Mr. Council, one thing is that, you see, in 2019, there was no COVID.
Hello?
2019, there was no COVID.
Yeah.
I can understand 2020 because there was COVID, but 2019, there was no COVID. So you should have paid some amount there.
So, my lord, since the beginning, this is the state of, my lord, will kindly see, supposing I am allowed to fish in 100 square feet of an area. If, my lord, 70% of the area is, my lord, eroded and filtration takes place, then how do I fish and pay the revenue? That is the issue. My lord, end of the day, what your lordship is testing is violation of Article 14. My lord, you yourself, your primary authority say the state of affairs. Then how can you demand the full revenue? I am not saying I will not pay.
No, but then why aren't you paying at least for the 2019 year? 2019, how much is he supposed to pay?
Even, no, 19 revenue is clear.
He's saying that nothing
He
is
is not
paid.
easy. My lord, 19 revenue I paid. Paragraph 8, my lord. Page 12. That the petitioner was served notice dated 21/21 for clearance of area revenue of first, second, and fourth, third, fourth fees for financial, and subsequently notice was also issued to the petitioner to pay area revenue. On receipt of each and every notice, petitioner approached before the concerned authority and paid some amount to some extent and expressed about hardship as caused by reasons stated above. Respondent suggested petitioner to keep on paying the revenue as far as possible by considering the pandemic situation and the 7 years lease period. Moreover, assurance was given by respondent for consideration of application submitted by petitioner for grantor. My lord, everything started with year 21, not for 9. I learned friends take the instruction. Therefore, my learned friend should take proper instruction. Last time the court instructed him that under these circumstances he is prepared to 5 lakh, whether they can allow us or not. They should say yes or no, then court will decide.
That's what I can instruct, Lord. That instruction I have. I will instruction I have. Lord, we have already cancelled. That cancellation part is L because he has not paid the revenue.
Cancelled when?
Cancellation, my lord, was on 31/24,
31/20.
This year.
January.
And we have taken possession also, Lord. We have not put on sale, Lord, because there is a pending due to pendency of the case, Lord. But here we have already
Okay,
cancelled.
but what's happened to this reassessment of revenue?
What's it? That reassessment of revenue, Lord, has to be approved by the POD.
Correct. No, one thing is that it has to be approved.
By the,
It doesn't mean
but
that.
if he deserves it, if he deserves, let it be 40 lakhs. We will return it, Lordship. That's not an issue. But he has not paid the revenue. He should have paid, Lordship. Some amount he has not paid. And here in the statement, he has stated that he can pay 7,68,000. In the vernacular, he himself put a figure that he can pay 7,68,000 as a yearly done since he said earlier settlement. That is his demand, Lord. In the vernacular logic. This part I can in the vernacular logic.
If I record affidavit,
Logic. That
and you also include this reassessment of revenue.
Okay.
How much is it?
1.1 is come, 70.
Mr. P. Sharma, Learned Counsel for the AFDC, shall submit an affidavit, which should also include the reassessment of revenue done in person to the Board of Directors meeting. Resolution passed on 28/7/22.
Now it is the board resolution. Now he's saying board approval is required. Can you see that?
Anyway, there are
That's the board's resolution. And he says you board the resolution.
no, but then board resolution.
Has been approved.
No, but then they have to accept it also.
No, they have
It might be.
accepted.
It might be.
It is
Let us
next
see.
meeting, it is always approved, my lord.
Let us
If
see.
a meeting is held, no, now we are in 24, that's a resolution of 27
No, no.
July.
Let us see if it is approved. It is good.
It is approved.
Let us see if it is approved.
Specifically, my lord, whether in the next meeting that was approved or not. If it is
First up,
approved, then I am entitled to the benefit.
further, the Mr. P. Sharma shall produce the record showing as to whether the reassessment of revenue done in terms of the Board of Directors resolution dated 28/7/22 has been approved,
Ratified in this
has
subsequent.
been
board.
ratified, and has been approved in the next meeting. This is the matter. When? Sir. Sir? When do you want?
13 months.
13. 13 months.
Let this matter come in motion, follow my.
Yes, yes. Yes, sir.
May I please, Doctor? My lord, here petitioners have the tenant, my lord, they running their small business in the Panchayat area. The petitioners are allowed 4 numbers of rooms by the Panchayat to run their business in the,
Where is that? Where is that permission?
that is agreement, my lord, page 15, my lord, annexure 1,
50.
15. Annexure 1, it is an agreement.
Yes.
As per that agreement, my lord, the first party, that is the president and the secretary of the Panchayat, and second party, one of the petitioner. This agreement is made on 6/1/23, Monday, in which the first party and the second party have signed a rent agreement for the purpose of business in respect of room number 10 of Tukrapara Gaon Panchayat complex under Tukrapara Gaon Panchayat as per the following condition. Dear my
There
lord,
is something wrong.
my lord,
It says here will be for 3 years, which is from 2/1/23 to 31/12/26. This is for 4 years.
that's my lord, it is right like this, my lord, clause condition 1. Condition 1, it is right.
Condition number 2. I'm talking about condition number 2. Please read the
In my lord, yes. Condition number 2. Four, 5, 6. Yes, sir.
No, please read condition number 2.
Yes, sir.
Please read.
The term for the agreement will be for 3 years.
3 years. 3 years.
3 years.
Which is from?
Which is from 2/1/23 to 31/12/2026.
What does it mean? 23, 24, 25, 26. 4 years.
It is the wrongly written here, my lord, that is then and then also, my lord, 3 years is not complete, my lord.
It is 4 years, Mr. Council. This is 4 years. You're starting from 2nd January to 23.
Yes, yes,
So
yes,
whole
my
of 23, whole of 24, whole of 25, whole of 26. 4 years.
My lord,
There are certain discrepancies which the town secretary has now found out. So they are actually investigating into the irregularity. So usually, first of all, it's putting the tenure. And whenever the panchayat executes a agreement like this, it has to take the approval of the government. So those approvals are
Where
also.
where does it say that it has to be approved? to the-
My lord, these the notices at page 66. It's basically the rent termination notice. They've received a lot of complaints, so they investigate.
Yes,
First paragraph, my lord, with reference to the above cited subject, I'm writing this formal notice with regard to the distribution of rooms in the marketing shed situated in front of Tukrapara Gaon Panchayat. We have received several complaints regarding the allocation of these rooms, and it has become imperative to address these concerns promptly. To resolve these complaints and maintain transparency in room distribution, we request you to immediately close the room assigned to you in the marketing shed. Furthermore, we kindly request you to hand over the keys of the allotted rooms to the office of the Tukrapara Gaon Panchayat. Lord, considering the fact that the tenure of the panchayats have now ended.
not ended.
Tenure of the panchayats have ended, ma'am. So
Tenure of the Panchayat may have ended, but then their tenure has not.
tenure is not it.
You obtain instruction. Well, if you notice, will stay there. Heard, mister?
Okay, you come.
Here you are, Learned Counsel for the petitioner. Petitioners.
Yes, sir.
Who submit that the petitioners are running businesses from rooms which have been rented out by the respondent number.
Five.
Five.
5 and 6, my lord.
5 and 6. On the basis of agreement executed between the parties. He submits that the period of lease is till 31/12/2026. However, right, letters dated 19/2/2024 and 20/2/2024.
My lord, another is, my lord, from 2/8/23 to 1/8/2025.
Okay, whatever. Now before that. I will see. The December 25 and December 26. However, write letters dated 19/2/24 and 20/2/24, which they have been given notices to close the rented room and hand over the keys on the ground that there was some on the ground that complaints which had been received by them had been received by the respondents number 5 and 6 were
Only
to
5,
be
my lord.
Huh?
Only 5.
by respondent number 5 were to be resolved and to maintain transparency in respect of distribution of rooms. Issue notice returnable in 4 weeks. Mr.
Handing.
Handing accept notice on behalf of
15 1. My lord, 1, 4, 1 and 5. 1, 4 and 5.
145 and Mr. M. Chetria for 2 and accept notice on behalf of conflict. This is the matter of the 4 weeks to enable the respondents to obtain instructions and file affidavit if necessary. In the meantime, the letters dated 19/2/24 and 20/2/24 by which the petitioners have been directed to close their room and hand over the keys shall remain suspended. This is the next returnable.
Oblige.
One second. My lord, regarding the other case, we have received the instruction. It's a fact, my lord, we took part in the retail.
Yeah.
Then when the results were not out, when the other list was published, when we inquired, then we got to know that we are not.
So you are not allowed.
Participated in retail.
So interview you have got to participate.
Yes. That is what I had clarified. I mean, checked up.
Okay.
Okay, thank you. My lord, actually, we are fighting, somebody else is getting the benefit. In this case. because we and Milan Chodri's clients are fighting in this case. Because of the stay order, the earlier lessee is continuing.
On daily basis.
Not daily basis, because he was the earlier lessee.
Yes, I have clear notice. In the original execution logic, that issue is there in the 4064 logic. 4064 logic.
Yeah.
Here it stays there logic. Here the main issue is that this is the wife of the allegation is that wife of the actual fisherman has formed a society, and that can participate in the tender bid, and they become the highest bidder.
Who are they? The petitioner.
They are the
Okay, you're the petitioner.
no, I'm there. They are the applicant.
Now, who are those wives? The wives are petitioners here or not?
In the matter where I think my learned
Wives are in the respondent, as a respondent.
So, what is the group? What is the name? Huh? Nayan Jyoti.
Yes,
So so according to the FDC,
no, and this side.
the fishery department, the Nayan Jyoti self-help group comprises of wives of the fishermen.
We have given it, we stand by them, because we have allotted to them. They are the highest bidder.
You said they're the wives of the fishermen.
Yes, Lordship, they are the actual fishermen, as per our contention.
The wives of the fishermen are the actual fishermen?
Women.
Okay, so the self-help group of women who are fishermen.
That has.
They're- So you are saying that the wives of the fishermen, they are not fishermen.
he's stating the fact.
No,
That
I'm
is
not
actually
saying
the fact.
that. No, the allegation is that has to be decided by the court, Lordship.
No, you say, so please, when you say something, you see, please tell us what you really mean to say. That you're confusing the court.
That part has to be.
So your case is that this Nayan Jyoti self-help group
Yes.
comprises of women
Yes.
who are fishermen.
Yes.
Their husbands also are fishermen.
Yes.
So they are fishermen.
Yes.
Fisher women.
Fisher women. So that part has to be adjudicated by this court, Lordship. And whether their allegation is that the petitioners,
Nayan Jyoti is not
not actual fisher.
accepted.
So that part will take time, Lordship. So I'm praying, Lordship, in the interim, Lordship, the Lordship may vacate the interim till disposal, Lordship, with the outcome of the case, Lordship. Otherwise, it will be fast, Lordship.
Who is the petitioner? They are the petitioner.
We are the petitioner.
Which petitioner?
Let me start, my lord.
No, just a minute. Petitioner, what is your name?
I am Kumar Koiborto Gaon, means Silpo Samabhai Samiti.
Okay. So then there is another Natun Melang means Silpa
That is
Samabhai.
the defaulter society, my lord. Now, because of this stay order, they are getting the benefit.
Okay, they are the petitioner.
Without any settlement, they are running the business.
So we want to settle this highest bidder subject to the outcome of the petition, Lordship. Otherwise, it will go on, Lord.
Why don't you stop the business? The defaulter Natun Melang means Silpa Samabhai.
If there, I don't.
Not important that of the booking. They were they and the people that have already paid the box. That now it's taxed around that's your. They are not important.
Okay, is it possible for this court to decide a factual issue with regard to whether Nayan Jyoti self-help group, the members are fisher women or not?
Then there are tender conditions. If a party does not fulfill the tender condition, whether that party bidder can be accepted. or not. That's the only point. Not whether who is wife, who is husband, this is not the issue. Issue is there is a requirement of fishing experience. Now, whether the bidder has got fishing experience, the report of the primary authority says no. That is why, my lord, in this case, an interim order was, which is operating field. My lord, we all talk of gender neutrality, that's very well. But in certain sphere, my lord, even though we may not like it, it will exist. And lots of people kindly appreciate one thing. Assam, these settlements under Assam fisheries rules are not commercial transactions per se. These are all statutory contracts. there is a purpose. Because Lordship has seen that even the government is prepared to forgo the revenue also. As long as, my lord, people belonging to that group are gainfully engaged. Aurobindo Das, that's the full bench judgment of our High Court, my lord, where this honorable court has said revenue is not the prime concern. Unlike in a commercial contract, my lord, where revenue plays a very important.
What is that? What is that judgment?
That Aurobindo Das versus State of Assam, my lord.
Citation?
One second. My lord, AIR 1981 Guwahati, page 18.
It says what? Revenue is not the prime concern.
Yes, my lord. In fact, my lord, in one of the judgments, it's reported in 2021 DLR 2724, where a view was taken. That view has been appealed by the Supreme Court. In fact, I appeared in that case for the petitioner. Then issue was decided against me. Matter went up to Supreme Court. Supreme Court upheld the High Court. That revenue is not the prime concern. Consideration is what is the object of the rule, my lord. Peter,
If
Lordship can have this matter. Okay.
so no, then- okay, so can we start?
Yes.
We can start.
Yes, ma'am. Can I place the judgment for a moment, my lord? Please come to para 27 of that, my lord, High Court judgment, Manoj Kumar Sahani.
Yes.
While interpreting the provisions of unamended fishery rule, the Supreme Court had observed in the case of State of Assam versus Keshav Prasad Singh that no fishery can be settled except in accordance with those rules. By following the decision in the case of Keshav Prasad Singh, the full bench of this court in case of Aurobindo Das Supra has held that the purpose of settlement of fishery was not only to derive revenue but also to help weaker sections of the society. The members of the SC/ST community, by taking note of the successive amendments of the fishery rule, the full bench had observed as follows. The successive amendment of the rules noticed above show the anxiety of the government to give a better deal to the deserving persons, the cooperative society formed by actual fishermen, and actual individual fishermen by settling more and more fisheries with them. The emphasis in these rules indicate that government is more concerned about providing work to the actual fishermen to improve their lot than deriving revenue for the exchequer. So this is the view of the full court. Similar view has been expressed by division bench in so. So now my lord will kindly come to the Supreme Court order. Please come to the second page, my lord. Somewhere in the middle, we find that when the learned single judge by an elaborate and correct reasoning had upheld the decision of the state government, the learned judges of the division bench could not have interfered with the same unless the finding was found to be perverse or impossible. Against, my lord, single judge's order, we preferred a writ appeal. Writ appeal was allowed by. Against that, Supreme Court matter was taken. The appeal is therefore allowed. The interim judgment and order passed by the division bench is quashed and set aside. Judgment and order passed by the single judge is affirmed. But that was precisely the view, my lord. That revenue is not the sole consequence. So therefore,
What was challenged in this Supreme Court judgment?
my lord, a settlement was given to our
No, not
society,
this.
my lord.
So this is different.
Yes, my lord.
This is
Before I appeared for Manoj Kumar Sahani in the single judge, my lord. My case was my bid was higher. In fact, I was the highest bidder. I was ignored and the settlement was given to a society.
So you lost before the single day.
Then I won before the division bench. In Supreme Court, I again lost. Yeah. My lord, may kindly have another judgment, my lord, of a coordinate bench. Para 15, my lord. Para 15. Yes. And this is a judgment, this is a case, my lord, where my learned friend, Mr. M.K. Chaudhary, argued the point which will be arguing opposite. My lord, in this case, his contention was that fishing certificate is a must. It was upheld. Now today he will be arguing the reverse. That's the beauty. Para 15. It is the state government who is the settling authority in respect of a 60% category of fishery. The Deputy Commissioner Morigao in the instant case had published the NIT dated 28/12/17, inviting sealed bids from the intending bidders along with documents and information to be submitted before the time and date of therein up to so and so. The bidder had to submit their bids in sealed form enclosing all documents indicated in the NIT or before the time and date of date stipulated therein. As it is evident from the above, the petitioner society did not submit two number of documents: the fishing experience certificate and certificate as regards 100% actual fishermen of its member belonging to the scheduled caste and Maimal company. Kindly note, my lord, there were two shortcomings in the tender. Amongst others, one was fishing experience certificate. From the very wording of the proviso of Rule 12, it is evident that most essential requirement to be fulfilled by bidder to settle a 60% category fishery is that 100% of its members have to be actual fishermen of the scheduled caste community or Maimal community. Thus, the submission of certificate of 100% actual fishermen of scheduled caste community or Maimal community, one of the essential documents required to be submitted with the bid which was to be submitted in same form. It is no longer res integra in view of the division bench decision in so and so versus so and so that fishing experience certificate and certificate about 100% actual fishermen of scheduled caste and Maimal community undoubtedly falls within the essential criteria for settlement of 60% category fishery, and non-submission of such document renders of the bid of a bidder society invalid. So same is the case in the issue before the present case, my lord, where they do not have the fishing experience. Now, my lord will kindly take the writ petition, my lord. Please come to page 25. My lord, 23, the NIT starts. It is the translation, but even then we have given the relevant portion. Please come to page 25, my lord.
Which rate petition?
My lord, 4002. C. 14C, my lord. Fishing experience certificate issued by concerned district development office. Now, my lord, my lord, at page 27, it is in vernacular. I'm just reading it, my lord. Masmara Obhiggotar Praman Potra. That means certificate certifying that the members have fishing experience. So it is not there. Now, my lord will kindly come to page 46.
So they did not submit this.
They have submitted, but that itself will show they do not have the experience. Page 46. Good. Good. Page 46, my lord. Certified that the members of Noyanjuti Health Self-Help Group of Nokun Melang belongs to fishermen community. There is no difficulty. Their husband and other family members are involved in fishing activities and depending on fishing for livelihood. So whether they qualify to be an actual fisher, a person whose avocation is not fishing, let us not bring in the gender. Let us say person. A person whose avocation is not fishing, can he get the benefit of my lord? This statutory rule? Yes. My lord will kindly come to the rule 13.
Yep.
With the prior approval of the state government, not more than 60% of the fisheries in a subdivision available for settlement in a year shall be selected for sale under tender system only with cooperative fishery societies formed with 100% shareholders from the members of actual fishermen belonging to scheduled caste or Maimal community of the district of Kachar and registered under the Assam Fisheries Cooperative Societies Act. Settlement of all such fisheries, tender of which have been accepted under Rule 5, shall be the highest tender. The remaining fisheries in the subdivision available in that year under tender system of sale shall remain open for settlement to all communities, including cooperative societies as referred to in so and so. So, my lord, the mandate of the rule is 60% category of the fisheries are to be settled with a fishery cooperative society formed by 100% actual fishermen whose mode of avocation is fishing alone, or Maimal
And
community
they
of
have
the
got to belong to the SC.
yes, and Maimal community. My lord, the members of the self-help group who are women, my lord, their avocation is not fishing. Either they are members, they are fishermen, fisherwomen rather. Merely because their husband pursue and occupation, will that by itself would be enough when the settlement is governed by a set of rules?
So basically, your case is that the certificate of
Yes,
page
itself so
46 does not show that these members are secured. That's a bit.
and my lord, since it is governed by a set of statutory rules, therefore, my lord, there is no question of any leeway. There is no, discretion on left with the government.
So now, according to you, they have to show that the certificate shows that the
They are
secured.
actually onto fishing activity. My lord, kindly see, my lord, even a schedule cut by itself is not enough. His avocation must be fishing and his livelihood must be derived from. All scheduled castes are not entitled to get this benefit. So, my lord, therefore, going by that logic, my lord, if the government is so desirous of extending this benefit to women, they can always amend the law and bring provision, my lord. There is no difficulty. But until the law comes, when the settlement is governed by a set of rules, I don't think they can, my lord, exercise a discretion.
So they are the lowest, highest, and you are the second highest.
That is second hand. My lord, regarding, let us go to the settlement order, my lord. My learned friend has said that they are not defaulter. Let us see whether defaulter or not. Please come to the settlement order at page 31. My lord will kindly come to page 32. Serial number one, somewhere in the middle, my lord, at page 32. Serial number one, Kumar Kodborto Gaon Main Silko Samubai Samiti Limited, Kumar Kodborto Gaon,
That
has
is you.
submitted, and that is we. Submitted its bid in the name of its secretary. They have stated that they will pay annual revenue to the tune of rupees 4,51,000. They have also deposited 75,000 as security deposit. Sambai Committee consists of 100% actual fishermen. According along with the tender certificate relating to fishing experience, Bakijai clearance neighborhood, seen that the society is situated at distance of 150 meters from the fishery. An annual audit report have been enclosed. The caste certificate and Jamapati have been submitted in the name of the secretary of the society. Registration certificate of the society, PAN card and result have been enclosed as additional document. It is stated that number 11 Kokila has been settled since so by an annual revenue of so and it has paid the annual revenue, government revenue from so. Now, serial number 2. Self-help group has submitted its tender in the name of its secretary. So and so it is stated that they say in the tender that they will pay an amount of rupees 51,101 as annual government revenue. They have deposited 1 lakh as security deposit. Self-help group consists of so and so. They have enclosed fishing experience certificate, Pakija clear neighborhood, etc. situated at a distance of 3 kilometers. Caste certificate issued on the name of the secretary, copy of the etc. has also been enclosed along with the tender. In addition to that, copy of the registration. Now, regarding the third society, has submitted its tender in the name of secretary. It is stated that they will pay an amount of rupees 5,10,000. They have deposited 85,000 in security. They have enclosed the fishing experience certificate, Pakija, etc. It is in that society is situated in the nearby fishery annual report, etc. Now, kindly come to the my lord subpara. Your esteemed self is informed that the fishery was settled with Notun Malang with effect from 13 at a revenue of 12. And society failed to deposit annual government revenue at such a high rate. They filed application request for remission of revenue. Thereafter, authorities examined the report, prepared annual report, etc. Further, authorities had fixed the unpaid amount to the tune of rupees 11 lakhs north and grant extension of the term of the fishery with effect from 3 years from so. As per the said order, society was liable to pay an amount of rupees 22,30,000 and north. However, records reveal said society only deposited 13 lakhs and when they are liable to pay 9,50,000. So, my lord, as far as Notun Malang is concerned, they are defaulted to the tune of 9,58,000. That too for operating the fishery in the year 2013. So, this is the situation. Yes, I have quoted less than 4,51,000. They have quoted 6 lakhs and not. But my lord, the revenue is not a concern. Concern is whether you are entitled to the benefit of the rule. Object of the rule is to ensure that settlement is enjoyed by that section of the society who are backward, whose only mode of living is fishing and no other mode.
You have quoted how much?
4,51,000.
And they have quoted?
They have quoted, my lord, 6,51,101. So admittedly, my lord, they do not have the fishing experience certificate. And apparently, my lord, subject to what your lordship may say, the fishery rule do not extend any preferential treatment to fisher women. That fisher women, even without fishing experience, can be settled with a fish. When it is not there, not there. You cannot interpret a negative way, my.
So let us see how he interprets
Yes.
big protected.
And my lord, one more point government has taken, my lord. A private respondent, they have taken, they have made a statement in their affidavit.
Who is the private account?
My learned friend, Mr. Chaudhary's client,
Then he this
says
Natun-
open Belay.
Huh?
Says this second highest bidder who was defaulter and was not considered.
Okay, he's the second highest bid. And so she has made a challenge. though.
They have also filed it.
Okay, so you are the third highest.
I'm the third. In fact, I'm the highest valid bidder.
What is your amount? Five lakh. Okay, we'll see. Okay. Okay, now so
Hello,
you
one
have
more-
made a. They have been selected. They are the lowest, and they have been selected.
They are the highest bidder,
They're the highest, so they have been selected.
which has been stayed by this authority.
And so you have made them a party,
Yes.
and them also a party.
No, we haven't made. Oh, yes, we have made it.
They have made them. And then they have also put this selection to challenge. On what ground have they done it? As the petitioner. Same ground. Same ground. So and actually you have not made them a party.
My lord,
Okay, anyway, we'll see.
my lord, one point which has been taken by them in their affidavit, I'm just dealing with that, my lord. But they say, my lord, on the last date of submission of bid, we did not submit our Pakizai clearance certificate. They have also not done. The reason being, my lord, the ADC was busy in Guwahati with his view dancers, my lord, for creating that Guinness Book of World Record. So essentially, when he went back to Jorhat, then he issued the certificate that he also submitted, we also submitted. And this aspect of the matter was taken note of by the settling authority. So they have taken that point. So I'm just making it.
So that should not come in the way of deciding.
The larger point is, my lord, whether a fisher woman can enjoy any special or preferential treatment in the matter of settlement in the scheme of the fishery. That's the point. But that is my humble submission.
Only one thing is now, supposing we agree to your thing, now then your attack will have to be on her, and your.
Well, let's see the defaulter. Your lordship will have to
Now
record
we'll
a
have to-
finding.
we'll have to see, because they are going to say no.
No.
And then-
That lordship will have to take a decide, my lord, whether yes, if she is construed to be not a defaulter, she will get it because she has got a higher.
Okay, so 451 is
Kumar Kolkata.
Kumar. 5-1. And 5-1 is Natul. And you are Nayan.
That is my humble submission. Deep breath. What is time permission can I take? My friend would be there.
But my learned friend, although he is late, my lord, he has level beyond what is required in this requisition for deciding. So firstly, my lord, he was
He should have let him go first. Maybe he could have.
stayed back, no?
Now he's saying that.
No, firstly, my lord, he was harping upon the point that the highest bidder need not be given the
Yes.
need not necessarily be given.
Yes.
But then, my lord, there are other cases where it is said that, my lord, the interest of revenue of the state has also to be on that, my lord, I just take one.
But full bench decision is
That- These are single bench.
This is a single bill. This is a, my lord, division bill.
Single.
My lord, the relevant paragraph will be paragraph 8, last sentence in paragraph 8.
Yes.
where it is stated that it is a fact that the restaurant number 6 offered not better bill than the appellant, which inures to the interest of the government revenue. Therefore, judged from whichever angle, the restaurant number 6 society was clearly the most deserving tender for being conferred with the order of faculty. Now, my lord, the question that calls for consideration before your lordship is, my lord, where does a self-help group stand in this competitive bid? Self-help group. Because, my lord, self-help group has not been actually defined. What is a self-help group? It's an association of persons which join together for their livelihood, to make their livelihood important. That has not been, there is no law governing me, my lord, the self-help groups. But in 1972 itself, my lord, the NABARD has quoted this idea, from which the government also has made various programs for the self-help groups. Now, if your lordship kindly sees the Rule 12, under which the settlements are made. Rule 12, may I read it?
Yeah.
Because, my lord, self-help group finds place here. That is important. Except those referred to in sub-rule 8B above, all registered fisheries shall be settled under tender system of sale in place of sale auction. Provided that the government shall settle 60% category of fishery, that has been explained by my learned friend, Rule 13. For category of fishery with special category of cooperative societies, non-government organizations, and self-help groups consisting of 100% actual fishermen in the neighborhood of the fishery contract by the tender system. So, my lord, this is what the rules say. Now, your lordship has to look into the, my lord, the NIT where the conditions are laid down. If your lordship kindly takes up the NIT, the relevant.
No, but one thing is, what he was saying was that this is section 12 of the Rule 12 provides for the self-help group. But 13 provides that they have to belong. They have to be actual fishermen.
100% actual. Yes. There is
So you have got to show that.
Yes. Yes. For that, my lord, we have to first come to the conditions in the NIT. Okay. The conditions in the NIT, my learned friend had already drawn your lordship's attention to, that your lordship will find, my lord. Page 25. The 14, the tenderers belonging to Samabaya Samiti, NGO, SHG, self-help group, have to submit the following documents. A, 100% actual fisherman certificate issued by the ARCH. This is important. Issued by the ARCH. Then C, fishing experience certificate issued by concerned district development officer. That is fishery development. Now, so far as clause 14A is concerned, the 100% actual fisherman certificate is issued to be by the ARC, Asian Restaurant Cooperative Society. We approached the ARC to give a certificate, and the ARC has refused to give it because they say that we deal with only cooperative society. You are not a cooperative society. You are a self-help group. We cannot. Therefore,
Have you put that challenge? Have you challenged it?
no, I have not challenged it, my lord. My alternative is that I have to get it from the district as fishery development officer.
That the, when the requirement of the tender notice and the rules provide for a thing to be done in a certain way,
Yes.
can it be done some other way?
My lord, this is by the, my lord, requirement is by the ARCS, but ARCS cooperative societies, they deal with only.
Then you put a
cooperative-
challenge to that,
My lord, we are not challenging, that has been accepted by the government. I'll, my lord. Take
no,
up
but then
to the-
can they accept a thing which is not allowed as per the rules?
My lord, this document, the,
I do not know, 100% actual fisherman certificate has to be issued by whom as per the rules?
my lord, rules say that, my lord,
100% actual fisherman certificate is required. It is issued to be whom, by whom, that is not there in the rules.
Hey, sure.
Yes, my lord, that rule 12 is the only rule, 12 and 13, my lord, are the only rules. And my lord, the
System.
fishery department, they are the, my lord, author of this NIT. And they understand the, my lord, the conditions better.
No, that is all right. I'm not on that. I just want to know if the rules provide that it should be issued by the ARCA.
Rules do not provide that.
If the rules do not provide, okay, but then maybe they can deviate. They can deviate from those conditions.
That is what my submission says.
That is your submission. That's because they are the author of the
Yes, my lord.
tender.
And the rules do not say that it has to be issued by whom. Yes, a certificate is required by issued by whom, and it is understandable that, my lord, ARCS cannot issue the certificate because we are not a cooperative society.
Let me see what the
Are you referring to the rules? My the explanation 1 to rule 12 also speak of self-help groups.
yours has been issued by whom?
District Fishery Development Office. That your lordship will find at page 40. 46. In fact, my lord, their entire case hinges on this document, page 46.
Correct. So we will have to see. So now page 46,
Right.
when you look at it, there is nothing to show that you are involved in fishing. Yes. It just says you belong to the fishing community, fisherman community. But doesn't mean that you are, because they say they again qualified by the last sentence.
Certified that the members of the Naranjali self-help group, Nutun Melengao doing so, Panchat are belongs to, my lord, your lordship will think the language. That is why, my lord, this type of certificate belongs to fisherman community.
Full stop.
Oh, I'm sorry, my lord, this is their certificate. Our, this is also, my lord, their certificate.
Is it?
Their certificate, Nutun Mel.
No, this is your certificate.
This
Page
is not
46,
non-
non-duty.
No, not certificate. This is our certificate.
Yeah.
The husband and other family members are involved in fishing activities and dependent on fishing for
Yeah.
livelihood.
Does not talk about you. It talks about the husband and other family members.
Why not? It says that we belong to fisherman community and other members of the family are also involved.
And
fishing
yes,
activities.
no, since the husband and other family members, other,
Children. Now, my lord, now your lordship will have to look into this certificate along with the, my lord, stand of the authority. So they say,
no. You see, the basic thing is how to interpret this document. How to interpret? This is the English version, this is the original.
this is the kind of English, no, this is the original English.
It's not a translated English.
Not a-
Now the problem is here, I mean, you see, you can belong to any community, but your profession or anything might be different.
My lord, this can be interpreted both ways. My humble sir.
Their husband, so basically it shows that you are all wives. Husband and other family members are involved in fishing activity. It does not say that everyone is involved in the taking. It basically qualifies that statement
My lord,
of the fisherman community by saying that the husband and other family members
they are
are involved,
they are involved.
not
My
you.
lord, this is one document, and thereafter, my lord, the authority is making it. It's not that, my lord, they blindly give on the basis of paper. We make an inquiry, and thereafter only, my lord, it has been, the deputy commissioner recommend to the, my lord, government, and ultimately the government gives the settlement. Now, my lord, the petitioner has challenged on the basis of this, document only, my lord, they have challenged by. Now, if your lordship kindly see the settlement order regarding discussion of the writ petitioner, they also do not qualify. Third has bidder is one aspect. The another aspect, the settlement order says is that your lordship will come to page 32. It says, my lord, the caste certificate and Jamabandi have been submitted in the name of the secretary of the society. These are to be, my lord, in the name of the society. So they do not fulfill
Page 32.
page 32.
Page 32.
Fourth paragraph, it discusses the, my lord, Kumar Pogro account, Min Shilpo Samabhai Committee. The Meen Mahal has submitted his tweet in the name of its secretary, Sri Rohit Kumar Das. They have stated that they will pay annual revenue to the tune of rupees 4,51,000. They have also deposited 75,000 as security deposit. So thereafter, the caste certificate and Jamabandi have been submitted in the name of the society of the secretary of the society,
So it should be in whose name?
in the name of the society.
As per
My lord, in fact, my lord, the rules do not really say that, but my
what
lord,
does the NIT say there?
the NIT, my lord, in fact, the entire NIT has not been translated in annexed here. The requirement has been stated, my lord, in the NIT. That your lordship, my lord, we have got the vernacular.
Yeah. Term and condition number.
Huh? Yes, my lord, there is. So just, your lordship, just based on. Therefore, my lord, firstly, they have to stand on their own legs. And thereafter,
Okay, I get your point. Okay, Ronak stage. Ronak International stage where that uh, their cases cannot be considered if they do not fulfill the stipulated criteria.
I just.
So that is one.
And thereafter, my lord, I don't want to take about much time. Thereafter, I'd like to refer to what the stand of the Congress is. In their opinion. Because that is
No,
the
no.
most important.
First,
step.
first let us see let us not jump. You tell me which, so that they can have a chance to counter all.
Yes. 69 of it, the difference of- Go fine, go.
But then, if you all were going to take this stand, you should have translated this clause. Is this in your pleading?
Page 29 is the vernacular. I'm sorry, man, I have taken you. No, see. Better?
There is another point number 3.
Huh? Term number
3.
3.
Three.
What does it say? Translated into English?
No, it's not. I'm not been able to find out, but that's it. Discussed in some case law.
So that point goes.
My lord, individual, the document is in the, my lord, the tender is submitted in the name of the society. The document is in the name of the, even my lord, whether it is there, the tender conditions or not. It's in the name of it.
Can all this caste certificate be in the name of self-help group?
But it has to be in the name of the, all the members
Or,
of the
or
society.
can't each member have a caste certificate?
Only my lord, only.
How can a company or a association or a self-help group have a caste certificate?
That is what they have my lord submitted.
It'll depend upon the members of that group.
But
No, no.
previously, my lord, previously on that point, although it has been discussed.
Have you taken this? Have you pleaded? Is it a pleaded case of yours? Have you made any averment?
No, my submission is that, my lord, it is their case and the order of settlement is under that, and in the order of settlement that has been discussed. But then, my lord, previously on that ground, it has not been rejected. So that is also, my lord, another point I have to draw your lordship attention.
No,
to.
that
It
is
not
a
very
different.
clear.
No,
That has
so,
not been said.
so you have not put them. You have not put it to challenge.
Okay. Then, that's why, my lord, I wanted to draw your lordship attention to the affidavit of the government.
Government will take care of their own interest.
No, my lord.
You
government
take
is
care of
taking-
yours first.
Government is taking interest of the revenue. And given it to a,
No, revenue is one aspect. But the thing is that so there are two aspects. One is the caste, the certificate regarding your whether you are a fisherwoman or not. Page 46 has not been issued by the ARCS.
their affidavit, my lord. So, as per the- But my lord, the requisition that was served on us and the copy, perhaps my lord, a little different.
Shall we adjourn it for some time? We are not prepared at all. We are wasting time.
I'm sorry, my lord, because that particular clause I have not been able to find out. Yes, sir. In the, my lord, affidavit, the copy, my lord, which has been served on the government, that particular document has been annexed there. There, my lord, it is there. That, my lord, the notification on 18 January 2018.
Hey,
My lord, that also your lordship will file in the, my lord, vacating petition. Is 50.
Which read petition?
In his reputation.
50.
My IA number 2363.
IA, in IA,
That is the amount of application for vacating state.
page,
Page 50.
this is the press note. No,
No, this is a notification. Issued by the, my lord.
it starts from 49. Notification of 18 January.
18 January 2008.
Yes.
There, my lord, your lordship will find a lot of anomalous discrepancies have been observed while verifying the tender documents forwarded by the deputy commissioner so and so. Therefore, my lord, these are the guidelines. What are the documents to be submitted to the DCSDO along with tender documents?
No, where are you reading? Lot of,
No, first three paragraph your lordship can skip. Then, my lord, underline. Number one, documents to be submitted to DCSDOC along with the tender documents by the tenant. After three paragraphs, my lord. It has been underlined.
documents to be submitted.
Yes.
Yes, yes.
The following documents shall be insisted upon with the tender while quoting a NIT for settlement of a fishery by the DCSDO. Number one, 100% actual fisherman certificate. Submission of 100% actual fisherman certificate of Fishermen Cooperative Societies, SSG, NGOs issued by the ARCS indicating that all the members of the Fishermen Cooperative Society, SSG, NOGs are
So
actual fishermen.
again, ARCS.
Yes, my. Again, ARCS. Then, my lord. To schedule custom. Then neighborhood certificate. Neighborhood certificate is to be issued by the concerned revenue circle officer. Then fisherman experience certificate of Fishermen Cooperative Society, SSD, NGO to be issued by the DFDO. Clause 3 is the, my lord, DFDO, from where, my lord, we have obtained this one.
No, this is. One is fisherman experience certificate. That's a different thing.
Yes.
You see, being a fisherman and having experience might be different. You see, you can have experience of fishing by going on a fishing trip maybe 2-3 times in a year. But to be an actual fisherman, you've got your livelihood to depend on it. That's what it appears.
My lord,
The
in fact,
proof is-
your lordship is right in saying that, my lord, the certificate that has been produced, it keeps, my lord, many things wanting. That is, my lord, I agree to that. The language there, it gives something wanting, but what is the efficacy of the government, my lord? That is what I want to bring to your lordship attention. And if it is a defect at all, whether this is a curable defect or not. The efficacy of the government, your lordship will find in this petition. As your lordship.
Yes, this is petition.
Yes, sir. In the writ petition, if it is in operation by the respondent number 3, that is the additional.
Page. Affidavit of position. Page
Petition
50,
of position of the government.
page 51.
I think it starts at page 63, my.
In which date petition?
4002.
4002. Page 51.
63 is my lord.
63 is the running page 63 is according to me annexure 4, Roman 4.
My lord, the copy that has been served is saying that, my lord, page 63. If it is in operation by Nirmal Kumar Devnath,
Okay. If the 63 has been cut, it has been made 51. Okay. Anyway, yes.
Well, there, point of office. Copy of affidavit is out of.
Huh? Not served upon it.
it is your affidavit. I hear it.
This is respondent number 3. Yes. Not served upon.
I have not received it. I picked up in the file.
So what's the time? How, can it be that they have served on me and not the reputation? I don't know.
I don't know now. I don't know what to do.
Or you have to can you take the notice and the that they
For one. Can we see them in the note? Whether they have been given copy, received copy, so run the count, some S count,
my
26,923. No others, but this is for writ petition number. No opposition, that's what. There, only S count signature is it. No one else. They have not been given. Arey, we heard so much of time we have wasted. Nearly an hour.
Your lordship has given some time to this matter. It's not any day to close it. But
What choice do we have?
because I cannot put into difficulty.
Correct. Not only that, now I've got to rehear the entire matter. Anyway, right. Heard Mr. K. Chaudhary and Senior Counsel appearing for Nayan Jyoti Self-Help Group. No. Appearing for, sorry,
400.
Kumar, no, I'm not going by that. There are three names. Sir. Kumar, Kai Partha, Gaon, Mean, Silpa, Samabhai Samiti Limit. Here and after referred to as the Kumar Samabhai Samiti. Mr. M.K. Chaudhary, Senior Counsel, appears for the Nayan Jyoti Self-Help Group. Here and after referred to as the Nayan Jyoti SHG. The other one you make it Kumar SS. Kumar SS. And then out here will be Nayan Jyoti SHG. First up, Miss Kisom appears for Natun Melang Min Silpa Samabhai Samiti Limited. Here and after referred to as the Natun SS. First up, Mr. P. Sharma appears for the Fishery Department, while Mr. M. Chetia appears for point number 4. Who is point number 4? That's all. Right. Uh, the impugned order of settlement dated 15/7/23, by which the by which number 11 Kokila Park bracket A fishery in Jorhat district had been settled with no, not that. By which you cut, huh? By which you cut. Okay. The next paragraph. All the three before that you write the KSS, comma NSS and NSHG, amongst other. How many had participated in the tender process?
3 meters are damaged.
Only 3 of them had participated, not among, had participated in the tender process for settlement of number 11 Kokila Park bracket A fishery in Jharkhand. The no, first of all, on opening the bids of the three bidders, comma, it was found that it was found as per the following. Number one, KSF, before that, before the following, NSHG dash rupees 6,51,101. Then Natun SS number two, 5,10,101. Number three, KSH, KSS 451,000. Next up. As the fishery was to be settled with NSS, no, N is N, not NSS, it will be NSHG, NSHG. Being the highest bidder, comma, NSHG, no. Uh, KSS and NSS have made a challenge. They're already selected over. Yes, already selected.
I have been, my lord, given this, sir.
Oh, you've been settled.
Yes, that has been stayed.
But then, acha, that has been stayed. That's it. So whatever I said. Now, as the fishery was now, as the fishery was settled with NSS, NSHG, NSHG being the highest bidder, comma, the same was put to challenge by KSS and NSS by WPC number 4002/2023 and 4064/2023 respectively. Next paragraph.
The stay order opposing.
In which case?
We have filed both the petitions. And we have filed kind of stay vacating.
Okay, right. In view of the challenge made to the settlement of the fishery with NSHG, the orders have been issued in both WPC 4002/2023 and 4064/2023 in respect of settlement of the fishery with NSHG with the Nana JPSHG.
We have filed stay vacating petition in both the declarations we have filed the stay vacating.
No, that's another thing. Okay. Next paragraph. The learned senior counsel for KSS in WPC 4002/2023 and submit that in terms of Rule 13 of the Assam Fishery Rule 1953, hereinafter referred to as the 1950 Rule comma. The members of the self-help group are to be actual fishermen belonging to scheduled caste of the state or Maimal community. We submit that in terms of the NIT, the certificate, where is that NIT?
Page 23, madam. In 4002,
But where is the relevant, the NIT,
25.
whatever. We submit. In terms of term and condition number 14, bracket A. No, bracket C. He's talking about bracket C. no? Bracket C of the NIT, comma. Fishing experience certificate has to be issued by the concerned district development office. He has not made any submission with regard to 14A.
No, madam, I have made current is 14C.
However, a perusal of the fishing experience certificate submitted by the NSHG shows that the same was issued, no, shows that the same shows that the petitioners, no, shows that the members of the NSHG are not actual fishermen, though they belong to the fishermen community. The certificate, the fishing experience certificate dated 4/4/2023, issued by the District Fishery Development Officer, Jorhat, in respect of the NSHG, shows that the husband and other family members of the members of the NSHG are involved in fishing activity and dependent on fishing for their livelihood. Full stop. The said certificate does not state that the members of the NSHG, who are wives of fishermen, have any fishing experience. Accordingly, he submits that as the NSHG has not submitted the fishing experience certificate as required under Rule 13 of the 1993 rule. Read with term and condition number 14C of the NIT. Comma. The tender submitted by NSA should have been disqualified and no settlement could have been made with them. Next para. The learned senior counsel for the KFF submit that the full bench of this court in the case of Arabinda Das and Tapas Tilal Das versus State of Assam, 1982, 1 GAU LR 280, had held that the purpose of settlement of fisheries was not only to derive revenue, comma, but also to help the weaker section of the society, comma, with, comma, the members of the SC and ST communities. It further held that the emphasis in the 1993 rule indicated that the government was more concerned about providing work to the actual fishermen to improve their lot than deriving revenue for the exchequer. He accordingly submit. No, stop. He has also relied upon the judgment of this court in Dash versus Dash 2026 GLR 107, where this court had held that fishing experience certificate and certificate about 100% actual fishermen of scheduled caste slash mammal community undoubtedly fell within the essential criteria for settlement of a 60% fishery, and non-submission of such documents rendered the bid of a bidder society invalid. Okay, sure, no problem. Because we're not disposing it off today. I'm just keeping it so that next time I don't have to go through everything. Just before this 2020, no? Is that right? Oh, that's all. No, that's all. Then you're right. Next, the learned SCA Council, Mr. K. Chaudhary appearing for KFF, that submit that the bid submitted by NSG, NSHG should be declared invalid. Next part. Mr. K. N. Chowdhury, when counsel for the KFF further submit that the other bidder, that is Natun SS, is a defaulter. As can be seen from the letter dated, the letter number REV 13/230 2023 REV JR. Let me mention it again. REV 13/230 2023 REV JRP. Dated 16/6/2023. Issued by the Deputy Commissioner Jorhat. Which is to the effect that Natun SS had failed to deposit annual government revenue. No, that Natun SS had only deposited rupees 13,05,250 as annual revenue, and they were liable to pay rupees 9,58,558, which would be adjusted from the security deposit at the time of submission of no, will be adjusted from the security deposit which they had submitted at the time of its bid in the year 2030. He submits that in view of the stay order being passed in WPC 4002/26 and 4064/26 of regular settlement, no, the the other party, the other, the other, not the other, just say Natun SS has been allowed to continue operating the concerned fishery as it was as it was the earlier settlement holder since the year 2030. It submits that in view of Natun SS being a defaulter, and as defaulters cannot be settled with the fishery in terms of Rule 12, rule what? No. Yes, defaulters cannot be in terms of
Under page 60 of notification, my lord. The I 236.
no, there must be something in the rule also.
Certified clearance certificate is there. The provision for certified clearance.
Page 50.
Page 60 of the I 236. Filed in 400 of 2026.
Which, huh? Clause
Clause
4.
4. Relates to certified clearance certificate.
In terms of clause 4 of the notification number so and so, at page 49 of the other. Number dated 18/1/2018. And defaulter is, I think there's nothing in the rules. No, but where is it in the rule? Okay, it says returns. Come on, what have I said? Come on, the settlement of the fishery would have to be done. The settlement of the fishery would have to be done with KSS, Kumar SS, as it was the only remaining valid bidder. Next para. Mr. M.K. Chaudhary, the learned senior counsel for NSHG, on the other hand, submit that in terms of the judgment of the division bench of this court in the case of so and so 2018 2 GAU LR 19, it has been held that a higher bid is to the interest of the government revenue. And as such, a deserving tenderer would always have to be considered in terms of the highest bid submitted by the tenderer. He was saying something about Rule 12. What is this? What about Rule 12?
For rules, self-help will also
He submits that
settle with it, self-help.
he submits that in terms of Rule 12 of the 1950 rules, a fishery can be settled with a self-help fee. That self-help. That's all. He further submits that though term and condition 14 bracket A of the NIT require the 100% actual fisherman certificate to be issued by the Assistant Registrar of Cooperative Society. The same was issued by the District Development Fishery Officer. Why? Yes, why was it issued by the District Development Fishery Officer instead of the ARCS?
Certificate.
Okay, and
Yes, yes. Actual.
what? Yes, actual fisherman certificate is issued by the ARCS.
Yes, yes. 100% actual fisherman certificate. Yes, yes.
Correct.
The same experience.
That is why I'm asking you. Why you have not issued has this 100% actual fisherman certificate been issued by the ARCS? No.
No.
Why?
Because we are the self-help group, madam. And
Come on, as the said provision does not cover self-help group. That's all.
But PRCS cannot be certificate.
Full stop. He submits that. Assistant Registrar of Corporate Society, bracket ARCS, cannot issue a certificate, such a certificate to a self-help group. Full stop. It can only issue such certificate to a
Cooperative society.
cooperative society. Next part. Ms. Tiso. The learned counsel for the Natun Asset submits that. What? Yes, what is the submission, madam? With regard to defaulter.
You can put it on page number 109. That's the suspense order
No. So,
of the page regarding my picture. That's person that's subject in paper number
40,
109 4064. That's my register number.
what about it?
Yes, page 109 of my picture.
Yes,
The second paragraph,
yes.
with regard to the page, the Nutun Valley means it was by the this of the victim was by the society has submitted need of the society has submitted all the required documents as per the need, which are found feasible. That is
So that is the basic case.
that as regarding this, that further as per the portfolio members that are inhabitants of the area. They are very close to the beneficiary in question. They are very close. And the third logic, however, as per the report of DC society has an outstanding revenue amounting to rupees for last settlement period, including extended fees. The DC part of the total outstanding dues will be adjusted logically against
Okay,
all
but
the
there was a Bakitai case against you.
logically
Madam, was there a Bakijai case against you?
my instruction, there is no such case, and that about logically is the
Then page, yes, next.
for a second page, 86 logically. The ministry has been assessed for the devices that they have faced during the COVID period. Because of the COVID situation, because of the curfew lordship, they have been stopped from fishing and fishing at that about of others that was brought to the knowledge of the society of the department.
So anyway, so you're not a defaulter for
I'm
it.
the department.
Okay, right.
Don't pay.
Miss Tiso, appearing for the Natun Estate, submits that Natun Estate is not a defaulter. And this is made clear from the order ECF number 324802/18. E will be small e, T will be capital, F will be capital, then NO post of 324802/182. Dated 15/7/23, issued by the Joint Secretary to the Government of Assam Fishery Department. He also submits that due to the COVID pandemic, where there was a lockdown, the petitioner could not work, the Natun SS could not work, and due to which the outstanding revenue amounting to rupees 9,58,558 is to be adjusted against the all deposit submitted by Natun SS from the previous lease period for the fishery. So she further submits that as on date, only rupees 2,80,000, how much? 2 lakh, she submits that approximately 2 lakh rupees 85,000 is pending
Worship,
against the,
Worship, they are enjoying the fishery on the basis of the order that the 2060-2023, which is passed by the Deputy Commissioner Gunhar, head of the jurisdiction minor. There,
anyway, that's a different issue. You give your thing. Affidavit, next para. At this stage, it has come to light that the affidavit filed by whom? Filed by the respondent number 3 on 26/9/23 in WPC 4002/2020 has not been furnished to the to the to the councils appearing for Kumar SS and Natun SS. Accordingly, the same be furnished during the course of the day. Full stop. On the prayer of the council for the parties, list the matter. When? Fair mark. Right? 13, we have already fixed one for you. How many cases can you do in a day? 12 is good. Difficult, 13 is a motion day. Where is it? 50, 60 cases. Is it till today only? Interim order to continue till the next day. So you are enjoying the fish for the time being.
please, Your Lordship. I would like to withdraw the matter. Nothing survived. In fact, the contract was
I
for
know.
3 years.
3 years ago, yes. Mr.
FAR.
F.A. Ahmed, Learned Counsel for the petitioner. Says that he may be petitioners. Says that he may be able to withdraw the writ petition as the writ petition has become infructuous. Mr. P. Pathak appears for the respondent. The writ, the writ petition is accordingly dismissed as infructuous.
Happy to. What's the last location also there? Extend Lordship. This issue has already been decided by another bench.
So what has what has the coordinate bench said?
Dismissed.
Dismissed.
Same council also. Council also said Lordship.
Okay, right. No one appears for the petitioner on call.
Last location.
Petitioners on call. On the last occasion also, no one appeared for the petitioner. First stop. Mr.
K. Kulita.
A. Kalita appears,
K. Kulita.
K.
K.
Kalita appears for the respondent for the Oil India Limited.
Yes.
Oil India Limited and submits that a similar matter as that is WPC 264/2023 has been dismissed by order dated 20/01/2020.
Lordship, paragraph 3, Lordship, reference of this case. In paragraph 3.
On next paragraph. On perusing the order dated 20/01/2023 passed in WPC 264/2020. This court finds that the pendency of the present writ petition had also been reflected. However, as stated, as submitted by the Council for the Oil India Limited, the similar matter had been dismissed. By giving liberty to the petitioners therein to impede themselves in the proceedings of title suit number 101/2019 in Miss Bracket J case number 78/2009. Next paragraph. On considering the fact that the petitioner has been unrepresented on 2 consecutive days with, this court is of the view that the petitioner is not interested in pursuing the matter. But the writ petition is accordingly dismissed for non-prosecution. Right.
Wait, Your Lordship. Lordship, in this matter, we have filed our exhibit, Your Lordship.
Okay. To what effect?
Lordship, this is a FMP matter.
Huh?
Flood management program matter.
So?
Not,
Have you admitted to the amount?
not fully,
Amount is admitted liability.
Show me your affidavit if you have filed it today.
Lordship, this is not a complete one.
And how did you file an incomplete affidavit?
Even if I have not,
Huh?
I don't have the office copy right now.
You filed it today, Mr. Counsel.
Yes, sir.
How did you file it?
Lordship, I have given.
Have you been given a copy?
Incomplete copy given.
So you have admitted. So you still have to pay around 2 lakh something,
Yes, sir.
para 11. Then you pay that amount.
By the other cases of, this is the Ministry of Jal Shakti has to be implemented. Otherwise, if you not allow these expeditions, they will, after some months later, they will file for it. It will be problem for us.
What you do is, Mr. Counsel. They are also having a point. Because Jal Shakti has to give the money. Now, so you can implead Jal Shakti as a party.
Yes, Mr. Tayagi. Longer required.
Huh?
Work has been done under the government. And,
Mr. Counsel, it's like this. Supposing I am giving him 1,000 rupees and he has told you, go and get me some coconut for 500 rupees. And when you get 500, you give him coconut for 500 rupees, he doesn't give you the money. Then you are going to complain against him. But he is going to say that I did not give him that 1,000 rupees. But I have not been made a party. So he is asking you to make me a party. So he wants that Jal Shakti should be made a party. You understand now? Yes.
Yeah.
Either implead or easier ways you can withdraw this writ petition, file a fresh with this affidavit, and that might be easier, but whatever you decide.
But I will implement
You please, okay. Mr.
Alright.
Aran Das, submit that affidavit deposition has been filed on behalf of the Water Resource Department today. List the matter after 2 weeks. In the meantime, you file.
Or that matter, my lord, faithful municipality, my lord, similar things. State was directed to take.
I have Abhabda Mala is that for matter. Resolution 4 was I was like.
Huh?
Okay, resolution 4 by which matter the tender was to set up with the physically handicapped matter unemployed person in their system was taken. That resolution has taken of it. I have opened the part matter to Hanikram. Can you please try this?
Yes, you translate it. I do not know, I cannot read.
Yes. Can read.
Huh?
I can read it out.
Okay, no problem.
External seconded my lord. And the tender will be settled with my lord unemployed, physically handicapped and below 39.
What is the challenge in the writ petition?
Due to the price cap, 10% above the reserve price. Nobody, no bidder was eligible to go above 10%.
No, let us see, for setting aside the impugned, it says impugned memo. 3323, where is that?
Yes, that is the selection of the,
No, where is that?
that is 69. Then it is subject part. Vernacular is 70.
Is a number?
Look, serial number 13, Malak. Name of the respondent number 5, that is at page 70.
13.
Yes. The lordship comes to Malak the NIT process, that NIT that the subject matter. The NIT is at page 58 on Election Act.
Yes.
But my submission is that nowhere in the NIT, and I have included the vernacular from page 61 on it, my learned friends can rely on that.
Page 58.
58 is the translated value, 61 is the vernacular. Because nowhere in the NIT, any clause is there by which anyone can give it, it was supposed to be given any preference. There's no clause. Whether it is disabled, senior citizen, below poverty line, nothing like it. The NIT does not say anything that anybody will be given a preference.
Okay, that,
So
okay, but they have done it, how does it matter now?
look, it matters because
Where is the
it
public
matters because
interest?
it is wrong on 2 counts. One count is that they have arbitrarily changed the preference because they have introduced a preference clause.
Where?
This is the preference. They have
They have given a preference, how does it matter now?
because tomorrow they may include some other category. That is the division bench decision of our High Court, which relies on
But how, you see, let us see, where is the same rate,
yes,
same rate,
that
same rate.
per se, that was the illegality per se. Why the
Huh?
cap?
You have not put this condition to challenge,
Yes, I have put in the earlier writ petition where I was granted the liberty to come back again.
but in this petition you have not challenged.
Once the tender process is complete, my challenging the cap or not cap is not relevant because they have selected somebody on the basis of a tender condition which is not there in the NIT. Lordship will kindly have the ask.
Any citations in
Yes,
that?
I have given the division bench decision, I will also give the Supreme Court decision. So that, if I may rely on the Act of 2017, which is applicable in the present. The Assam Public Procurement Act. Had they followed it, then these things would not have come.
I have got only one judgment. One,
No, I'm good, because I'll read that. But we kindly have the Act of 2017, which is applicable. So this is the Assam Public Procurement Act 2017, Manoj. And Logic will kindly have section 3.
Yes.
Application. This act shall apply to all procuring entities referred to in subsection 2. For the purpose of this act, procuring entity means, Logic will kindly have to deem any entity or board or corporation or authority or society or trust or autonomous entity established or constituted by an act of the state legislature or an entity owned or controlled by the state. Plus, this is tender is under the Assam Municipal Act, constituted by an act of the state legislature. The Act of 2000.
what do you go to the point?
No, Lordship will have page, the para, section 27, award of contract. What is the
Yes.
criteria? Section 27, subsection 1, subject to the provisions of section 25 and subsection 2 of section 6. The procuring entity shall consider the bid as successful. A, where price is the only award criteria. The bid with the lowest bid price. B, where there are price and other award criteria. The most advantageous bid ascertained on the basis of the criteria and procedures for evaluating bid as specified in the bidding documents. But 27 1B is fairly applicable in this, because here there are supposedly two criteria. One criteria is the cap. Everybody follows the cap. Now, after all the bids are received, all the bids are the same. What is the question of giving preference to one bidder or another?
You have not put to challenge that thing.
After the tender is awarded, it is not necessary for that, because I have put it to challenge earlier, Manoj, and I was granted the liberty to come again. Now, Manoj,
Okay,
whether
you
by-
come again.
yes, Lordship has that order, which Lordship has quoted in the last order.
Okay.
I was given the liberty to come again.
But then you did not challenge out here.
Because it is not necessary, Manoj, because the fact is that I am not
That is no.
because I am not agreed by the cap per se, but the fact is that there is no other criteria at all. Is it A, B, C? Which one have they followed?
Okay, so 27 ABC does not be
No,
followed
they have not
accordingly.
followed anything, man. Because it specifically says where there are price and Lord we kindly have B again. Where there are price and other award criteria. We do not know what is the other award criteria. The most advantageous bid, ascertained on the basis of the criteria and procedures for evaluating bid, as specified in the bidding document. The bidding document is silent. They can tomorrow go for red-headed, blue-headed person. We do not know. What is this? How can they introduce something which is out of the blue?
Anything else?
Lordship will have that provision by section 1993, volume 3, GLC 195. 9.
Yes.
Lordship will have paragraph here.
Correct, 12.
Yes. Family. Reasons reflected in the order of the minister in charge, the respondent number 4 has quoted the lowest price is not in consideration. The other reason that the respondent number 4 is a government company is in challenge. We have carefully examined the tender notice and nowhere we find any indication that the government company would be given preference to others. In our opinion, when a tender is floated inviting offers without specifying any reservation for special consideration, the authority assigned with the duty to accept the best available tender cannot, during the course of consideration, attribute any preferential treatment to any class or group of competing tenders. This view has been a law for the country since the judgment in Harminder Singh Arora versus Council has been pronounced by the Supreme Court. The ratio laid down in the state judgment that the government may enter into a contract with any person, but while doing so, the state or its instrumentality cannot act arbitrarily still holds the field. If the state chooses to invite tenders, the terms and conditions laid down in the tender must be followed. Therefore, the reason that the respondent number 4 is a government company and hence selected for the work does not appear to be legally accepted. If it was the policy of the state to give preference to any government company or undertaking, such policy should have been made known to the intending tenderers from before. On this context, examination of the records necessary to see whether there are discernible reasons to accept the respondent number 4 as financially sound company capable of executing the construction work. This will be done keeping in mind the extent and limit of powers of judicial review available to this court. But before that, we prefer to refer this. These
that indication of preference has to be there in the NIT. Otherwise, it will lead to gross arbitrariness. Since I may now take a logic to the judgment in Harminder Singh Arora, which the logic that referred in the building. The logic comes. to 1986,
1986.
the SCR, page 60. The logic comes to page 72. Bottom line, page 7. Payment. It was next contended that the conditions contained in the tender notice did not contemplate of giving 10% price preference to government undertaking. Yet 10% price preference was given to the government illegally. And the policy of the government to give 10% price preference to government undertaking was discriminatory and violative of Articles 14 and 15 of the Constitution. The state policy places respondent number 4 above the appellant without any basis or reasonable classification. In the absence of any such stipulation in the contract, such price preference was unjustified. If the terms and conditions of the tender have been incorporated in the tender notice itself, and that did not indicate any preference to the government undertaking for giving 10% price preference to government undertaking, the authority concerned acted arbitrarily in allowing 10% price preference. Correspondent number 4. The only facility provided to the government undertaking was provided in paragraph 19, which contemplates that the central or state government department are purely government concerns need not pay tender forms, fees, and earnest money. This was the only concession available to the central state government or to the purely government concern, and no other concession or benefit was contemplated under the terms of the tender notice. If the appellant had known that 10% price preference to government undertaking was to be given to respondent number 4, the appellant would have taken every precaution while submitting the tender. Now, further development will come to page 75.
Yes.
The so and so appearing for the respondents has contended that respondent number 4, being the state government agency, was rightly awarded the contract as per the policy of the government of India laid down in so. The policy adopted by the state later came in after the 1672 when respondent number 2 issued tender notice for the supply of fresh buffalo or cow. As such, the notification dated so and so is of no avail to the respondent insofar as the acceptance of the tender of respondent number 4 is concerned. Acceptance or rejection of tender made by the appellant or the respondent number 4 will depend upon the compliance of the terms of tender notice. It is true that the government may enter into a contract with any person, but in doing so, the state or its instrumentality cannot act arbitrarily. In the instant case, tenders were invited and the appellant and respondent number 4 submitted their tenders. The tenders were to be adjudged on their own intrinsic merit in accordance with the terms and conditions of the tender notice. It is only and only the terms of the tender notice which shall govern. The tender notice did not indicate any preference on any ground of handicap, poor, anything like. He may have got some concession in, let us say, if somebody is below poverty line, this tender is 1.65 lakh. What is this? And there is no document even to indicate that in the affidavit in opposition.
So you should have been chosen over him.
I'm not saying I should have been chosen.
Then who should have been chosen?
Not necessarily, but this arbitrary clause, this arbitrary selection, this post-award process, this is absolutely arbitrary because this will encourage them to commit more arbitrariness. The only way forward is to have a retender. Let there be no open field. Let there be
You should have put a challenge to the clause.
I did put a challenge. That is what I'm saying. That and this court at that stage, the difficulty is if I put the challenge of the clause after the tender is awarded, then I am again busy. I am again
You see, you have to put a challenge to the clause prior to submitting a tender.
yes, I did so. That is the liberty that was granted.
But then that was liberty. But in this present petition, you have not put a challenge.
Look, having participated in
That has now ended. You are given the liberty to challenge here.
if I put a challenge to the tender condition after participating, then I am again exempted because then this court would again say that I have participated in the tender with open eyes.
No, but then you could have at least argued.
I put a simple question, this resolution that they are saying, is it anywhere indicated in the NIT?
Different.
There is nothing there. The resolution, tomorrow they can take any other resolution.
That is, of course, that is a different thing, but then at the end result,
Four are similarly placed, my lord. Where is the ground for giving preference to anyone? My lord? The obvious question would be to go for a return, but let there be an open selection, open field. And that is exactly what the Supreme Court and division bench has held.
here also it's an open field.
No, but it is not.
In fact, it was a first. The open field was limited.
Yeah.
But then the problem is now it's the way it has gone about. We should have. Now it's too late, I think.
No, my lord, there is no question of too late. Just two
Well,
days that the Supreme Court has held, my lord, that
well,
question is always there. I'm not asking for restitution. I'm only asking for
Maybe not for you, but for me, who's going to write the order, I'll have to see what I decide on that.
that is of course, my lord, I must say. But the fact is that, my lord, this kind of resolutions taken by the board without conforming to the Act of 2017, which is
Okay,
binding.
anyway, let us hear. I think that's your case only.
Look.
Yes, what is your case? That board, what does it say?
But it says that, my lord, preference will be given to the unemployed.
Just tell me one thing. The NIT was dated what? 14/3/2023. Bid was opened when? Oh. 24/3/2023. Okay, now what is the board resolution?
Both resolution number 4, my lord, dated 21/2/2023.
Sorry, the tenders were open from 27.
27.
Yes.
Yes,
Board resolution was 21/2/2023, resolution number 4, my lord.
yes.
Section 5, date
No, what does it say? What does it say?
in particular, my lord.
So please translate.
Yes, my lord. It
So you read it in Assamese first,
yes, sir.
and then you translate, and they will correct you if they are wrong.
Yes. Resolution number 4, আজি সভাৰ আগন্তুক 2020-24 বিত্তীয় বৰ্ষৰ বাবে পৌৰসভাৰ অধীনস্থ বজাৰ সমিতি পাৰ্কিং আদি নিবিদাৰ বিষয়ে আলোচনা কৰা হয়। এই আলোচনাকালত যোৱা কেইবছৰমান ধৰি নিবিদা লাভ কৰিবৰ বাবে অতি উচ্চ হাৰত নিবিদা দাখিল কৰি সময়মতে কিস্তি টকা পৰিশোধ নকৰাৰ বিষয়টো অতি গুৰুত্ব সহকাৰে লয় আৰু এই সিদ্ধান্তত উপনীত হয় যে আগন্তুক 23-24 বিত্তীয় বৰ্ষৰ বাবে পৌৰসভাৰ অধীনস্থ বজাৰ পাৰ্কিং আদি নিবিদাৰ আধাৰ মূল্য 10%তকৈ বেছি নিবিদা গ্ৰহণ কৰা নহ'ব আৰু লগতে নিবিদাকাৰীয়ে আধাৰ মূল্যৰ 5% আমানত ধন স্বীকৃতি হিচাপে নিবিদাৰ লগত কাৰ্যালয়ত জমা দিব লাগিব। ইয়াৰ উপৰিও নিবিদাত অংশগ্ৰহণ কৰা নিবনুৱা দৰিদ্ৰ শাৰীৰিকভাৱে অক্ষম ব্যক্তিক প্ৰাধান্য দিব লাগে বুলি সভাত সৰ্বসন্মতিক্ৰমে সিদ্ধান্ত গ্ৰহণ কৰা হয়।
Okay, now since I've understood it now in English,
There it is resolved then, my lord, that since, my lord, some bidders did more than the bid value, my lord. That is why it is decided that 10% above bid value will not be considered.
no, above 10% will not
Above
be.
10% will not be considered. And
Ah,
what they say the resolution of fees that earlier, my lord, there was a, my lord, procedure where, my lord, separately rates were being quoted. Thereafter, my lord, the bidders, they were unable to pay the rates, my lord, in time, causing loss to the municipal court. Therefore, they had taken a decision now to fix the cap, my lord, on the amount of bid that is to be given. That is what they say. And thereafter, they say, my lord, that during the process of consideration, they will, because now the bids were equal in all respects, my lord, the amount was same, so they have given preference to, my lord,
but this is prior to the bid being open.
prior to the bid opening,
prior to the opening.
So so they'll give preference to this handicap.
handicap, my lord.
So so how does it matter if all things are equal? They give preference to handicap. How does it matter?
This is even
What
before
public-
the NIT was issued, my lord.
How does it matter?
21 to
You see,
20.
preference will only come into effect when everything is equal.
No, if I may say.
You had quoted the same amount
The
as the.
resolution is dated 21/2. NIT was issued on 14/3. 1 month prior, they had taken this decision, but is it reflected, my lord, in the NIT?
No, whatever
There
it
is no
is.
such clause in the NIT. It is behoves the Act of 2017, Section 27. Then why the Act is enacted? Why it is not enacted it in a vacuum. There is a purpose. Transparency is the purpose. Why did they not include it in the NITV? You would have put it to challenge if that's it. They, not the thing. They can tomorrow. They can. This is misutilize this as a precedent. And if
No, you challenge this condition, like, you challenge this board resolution that there cannot be a cap on the ceiling,
Because we are
a
almost,
cap or
we are
a cap on
almost,
the.
they have not even filed an affidavit. How can I put it to challenge?
Huh?
They have not even filed any affidavit in the 1 year that is not. The state has not.
In your writ petition, you've got to challenge. You cannot challenge it now.
No, this tender is almost
Right.
the same.
Till the end. Heard Mr. Ganguly learned something for the petition. Yes. I've not heard.
Chinese speaks, let us for time being assume that everything in the NIT is wrong, madam. Every action by the board is wrong. Then, my lord, kindly come to his prayers. In the prayer, he says, my lord, on the basis of these contract and these tender for the procedure, he is to be given, my lord. Because, my lord, earlier he was running it for 50 years and all, my lord, so he is to be given. So, each, my lord, that is the prayers, my lord. Kindly see, my lord.
What is this? This tender is for what? The
This is for, my lord,
Paltan Pukiri.
Paltan Pukuri is a, my lord, is the tank. The pond, my lord, in Jaipur, where, my lord, those famous lichi, my lord, those are grown, my lord.
Okay.
So, it is there. Here, my lord, kindly see, my lord. Issue an appropriate writ, that is the page 19, my lord.
Yes.
Issue an appropriate writ, order or direction setting aside the impugn memo number so and so, dated so and so, issued by the response number 3, by the response number 5, has been selected as a successful tender in respect of the Paltan Pukuri pond.
Issued by the respondent number 3 to the respondent number 5.
I have the response number 5.
Yes.
To the
Yes.
private. Then, my lord, kindly see, my lord. Issue an appropriate writ, order or direction directing the response number 3 board to award the tender lead in respect of the so and so to the writ petitioner. Issue such an order or direction in favor of the petitioner and against the respondent as may be deemed fit and proper in the interest of justice. My lord.
So there were five, I think,
Response.
5
Four.
bidders.
4 bidders,
Four
out of
bidders.
which, my lord, he and his son were 2.
Oh, here is the
He and his son were 2, and there were 2 others, out of which, my lord, because of my special consideration, I was allowed. That is the whole. But on these judgments, which has been cited at that point of time in 86, 83, the concept of free play in the joints had not yet been considered, my lord. Those came later on. So that free play in the joint is always there in public interest, my lord. And each party is suffered. Because the interest of the court is to secure that the public interest, my lord.
Correct.
And when the money is, my lord, already connected.
money is there, where is the public interest is not affected.
Not affected. So it's a private dispute between 2 tenderers, and let him go to the civil court for whatever damages he has supposed. That is the law, man.
Any judgment?
Yes, my lord. My lord, 2005, 6 HCC, my lord,
Just a minute,
138.
just a minute. 2005,
6 HCC,
6 SCC,
138,
138,
paragraph 11.
11,
The right to choose cannot be considered to be an arbitrary power. And paragraph 12 says about the fair play in the job.
anything else?
Then, my lord, the Sterling constituency theory, lordship is aware, my lord.
No, I don't know anything.
Then Jagdish Mandal is there, my lord, that is 2007, 14 HCC 517, which states, once having participated as has fallen from your lordship's mouth, my lord. Having participated in the tender process, my lord, you
Give me the citation, give me the citation.
2007, volume 14 HCC 517,
2007,
14 HCC
14 SCC,
517.
517,
Para, my lord, I have no written number, I'll give it to him. After just some time, I'll give it.
You give me all the citations, don't give me too many.
No.
Give me
I'll
just
give
2, 3.
3 citations, 3 citations. Okay. All right. Which Mandal is entitled to me once having participated from challenging the case. It's the problem.
I know, the correct. You are in a bind, but the problem is, but there was something there. You see, when you have been given the right to challenge a certain clause, even after participating,
No, Jagdish Mandal is basically in
that point.
that condition was there. It is entitled to me. How can I come and begin?
Correct. There is that.
I'm relying on that. No, but then the earlier order was.
Then you could have said that
Yes,
you shouldn't have withdrawn your earlier writ petition. You should have taken it to its logical conclusion.
Anyway, Malad, I rely on the thinking because that gentleman judgment and whatever they are, regardless of whatever my learned friend is saying, they are still good law. They have not been overruled or set aside or distinguished in any way.
But then Jagdish Mandal also says
So this might be-
that it should be, unless it is very, very unreasonable, then only. Now, what is so unreasonable when everyone has quoted the same amount?
There is a simple issue. There is only one. That when all are similarly situated, then should they not go by 27 of the Act of 2017? Or should they,
What about the PWD Act?
PWD Act will not apply in this.
No, but why don't you take the ratio? No, they are suffering, handicapped in life. As against a full-bodied person like you. Let
I am
them,
up to 75.
and you have been looking after making money for the last 50 years. Let this person also,
Isn't that?
that's what I'm just asking. There's one way of looking at it. Anyway, right. I heard Mr. A. Ganguly, learned counsel for the petition, and Mr. M. Chetia, learned counsel for the respondents number 1, 2, and 4. Also heard Mr. G. Chaudhary, learned senior counsel. Learned counsel for the respondent number 3. Five. Huh? That's what I said, 1, 2, and 4. How you think this last part of it? We'll just say hearing concluded, judgment reserved. I'll give you dictation now. Apana.
I'll just pass.
Yes, I'll give dictation now. I'll still pray. Otherwise, I'll forget. Unfortunately, I have written notes here in my cause list. To be my
I'm with you. After your Oscar, I was representing the opposite party in the REIT application. Also, we come to page 18 and 19. The petition is, I'm not filing the Wakalnama, your Oscar, but the order password is on the phone. Prayer the review. Like a review because I'm the opposite party.
You're for the opposite party.
I'm the opposite party, not filing the Wakalnama. I am.
You're not the review petitioner.
No, I'm not.
Not a the review petition.
Okay, you're the review.
I'll find the Wakalnama.
First dates on the lot, he is appearing not able to.
You find it for color number first.
I will. I'll do it.
Steps have been taken. He's the only one. He's the only one.
I repeat,
Okay, Mr.
party is the return.
RPS, I'll just submit that he will file his affidavit, he'll file his Vakalatnama within how many days?
Within 2 days.
2 days, within 2 days. List the matter in the next week.
The people.
Make the proposal. But may I invite my lord's attention to
Okay.
page number 68. Page number 68. We will be on a consensus matter.
Huh?
Page number 68. We are challenging rather, we are praying that serial number 1 and 3 be deferred until 20th of June. 1 and 3. So far as 3 is concerned, we are paying rent. We are there. There is no difficulty with that.
Are you paying rent for the
Yes, yes.
veranda?
Yes, everything. It covers. We are paying rent. We have that's understood. No dispute on that. But so far as 1 is concerned, we have submitted representation at page 101 that we have developed the software, hardware in doing it, of course. But they have a right to take a call. It does not fall stricto sensu within this plant and machinery. So may I pray, subject to his that the matter be disposed of. So far as 3 is concerned, therefore till 20th of June, till then we are there. So far as 1 is concerned,
Till 20th of June.
20th of June and not a demo.
No, but what?
But subject to what he says, I'm keeping my thing. And so far as 1 is concerned, let them take in poll on the basis of page number 101. They'll do inspection. If they have a soft heart, maybe yes.
Section not required, they just have to take a decision.
I mean, we have developed software hardening.
That you have done on your own.
But we,
It's like you building a road and saying, though I have not been given any work order, nothing, you give me what for my work done.
my lordship, if I say, in all fairness, that is developed for the purpose of after dismantling everything, it's weighed there, and the weight things are stored. En route, it's
And
taken.
that was not part of your contract.
No, I understand. Let them take a call on number 1.
What, yes, Mr.
And Lordship, he was participated in the auction process.
So that is an
Yes, sir.
He that weighbridge, so he'll got no, nothing. You take a decision on this, sir. You take a decision.
And so far as 3 is
As
concerned,
so far as 3 is concerned, what is to be done?
Three, Lordship, we admitted that there is an agreement, Lordship, and till completion of the agreement.
He'll continue.
Yes,
28th of
he will continue on 28th of June,
2-0.
2-0.
not extended after that.
That is entirely up to you, Mr. Council. Entirely up to you.
But regarding other items,
Weighbridge, dispose it off, take a decision.
Take it.
If you finish it off tomorrow, good enough. If you want to take a decision in July, that's good enough.
He
But
can-
till you take a decision,
we
you
speak.
let him remain. Let this not be effective. Only problem is the third party rights are there.
No. Third party letter of award has not been issued as on date. What happened in MSTC is that it's an online e-auction. Once the purchaser, successful auction purchaser firms, they have to issue a letter of award. After that, it's made known. So he's in the dark. We are not objecting to the auction, nothing.
Okay. Heard Mr. F. Panik, learned counsel for the petitioner, and Mr.
J.K. Goswami,
or
Spanish office AIDC.
standing counsel AID. The petitioner's case is that the petitioner was the successful bidder in respect of the e-auction sale to lift inverted commas plant and machinery of Nagaon paper mill without land, inverted commas close, on in inverted commas as is where is basis. Comma. Full stop. Subsequent to the above, comma. An agreement for sale of plant and machinery dated 2023 was reached between the petitioner and the Assam Industrial Development Corporation. Bracket AID. Subsequent, thereafter, the AIDC issued a communication dated 18/7/23 addressed to the petitioner, whereby the canteen and forest office building at Nagaon Paper Mill, comprising of the forest office, training center and veranda.
Veranda is not there.
Well, it is
Like,
incomplex. I have a room with a veranda. They are not objecting me to, we store it there. But I take it this way. I demolish the room, the veranda also goes. I take the room, I have the veranda.
Veranda is separate.
But they,
Okay, I won't mention that. I won't
not,
mention that.
not sure.
And just say, whereby the canteen and the forest office building at Nagaon Paper Mill were allotted to the petitioner at a monthly rent, at a total monthly rent of rupees 30,307 till 20/06/2024. Next one. Subsequent to the above event, the AIDC has issued an e-auction notice dated,
The date is not there, Milord. The
e-auction notice
details are there.
for demolition and disposal of amongst others, the weighbridge, the forest office, training center and veranda,
And the parts.
and the parts so dismantled and stored by the petitioner inside the rental premise. Next one. The petitioner's counsel submits that a representation dated 22/2/2024 has been submitted by the petitioner. Where is this?
101.
Requesting the AIDC to withdraw the above weighbridge, forest office, training center
And number 3.
and veranda,
At the next page, Milord. 102.
and veranda. And veranda
And the fixed.
from the e-auction notice. As the petitioner has developed the what? Software,
The hardware and software.
the hardware and software for the weighbridge.
The one line more. Page 1023. Items assembled and stored. That may not be put up. Milord.
To stop further, the items assembled and stored by the petitioner in pursuant to the earlier e-auction notice should also not be auctioned to some other person. Next one. Ms. Nail Bani, the learned counsel for the petitioner, that the AIDC may examine, should take a decision. To take a decision on the petitioner's representation with regard to whether the weighbridge should be left out from the purview of the e-auction notice
Until 26. 20.
until 20/06/24, which is the date his lease on the forest office. Forest office,
Not only my entire rights. to
forest
dismantle-
office and lifting of the material would expire. Mr. J.K. Goswami, learned counsel for the AIDC, submits that he has got no objection with the statement. In view of the consent of the parties, the AIDC will take a decision on the petitioner's representation dated 101, section 22/2/2004, with regard to whether the weighbridge should be left out from the e-auction notice. Till a decision is taken by the AIDC.
In regards to other items.
The other thing.
The other thing is, till decision is taken by the AIDC with regard to the weighbridge, the petitioner should be allowed to use this thing. If allowed by the AIDC. With regard to the other leased out premises of the Navang paper mill
Can be completed. The articles.
and the articles wrote by the petitioner. But then I hope you have not stored it everywhere.
No. In the room, the page number 105.
As
105.
stored,
Photograph.
the petitioner should be allowed to. The petitioner should not be disturbed.
But other items,
Item number 2 is what?
No, two, no, only one and three. Two, should not be disturbed. Should not be disturbed. Till 20/06/24. This code again makes it clear that that which is that item?
60.
Uh, That
Rest.
the items number, serial numbers 2, 4, 5 and 6 is not the subject matter of the writ petition. And that serial number 1 will, the issue of serial number 1 will depend on the decision to be taken by the EID. That's all.
That's all.
Hey, time frame not
No,
required.
not required. Not required. Like that.
The writ petition is accordingly disposed of. Give me some note.
First of all.
Yes.
So you got, against the got order rejecting the equipment of the party. The rejecting was referred yesterday, the rejecting was.
Ah.
Before I take it, the very strict case. Two preliminary objections have been raised by the project. One, that this Honorable Court does not have jurisdiction
Does not have central.
jurisdiction to entertain the petition. And secondly, there was suppression of material facts.
Yes.
As after the filing of the liquidation, an appeal was also preferred against the blacklisting order.
Appeal was preferred against the
Blacklisting order. Before the
authority.
itself.
Before whom?
Before the corporation.
Before the
Responding of
HPCL. HPCL.
Right.
That was rejected.
No, will not be withdrawn it.
Withdrawn. Why?
Not because that was a mistake of law, because the petition was already filed.
Huh?
The petition was already filed before this Honorable Court.
When was the writ petition filed?
By law. 18.
In 12/23. When was appeal filed?
On the same day in the night.
Appeal filed on same day
Then,
and withdrawn on
withdrawn, I given the affidavit of the reply, 14th. I annexed the order of,
14/2/23.
24.
24.
That has been dismissed. On below 14th itself.
Withdrawn, you mean?
We withdraw, and that has been dismissed by the one corporation. On 14th, was withdrawn, I withdrawn.
Dismiss has withdrawn.
By the way.
Yeah.
So I have to certify also first on these two preliminary issues before going to the
Yes.
merit.
Appears so.
And as you also know, through the T26(2) of the Constitution of India. If any part of the prosecution has arisen with the taking jurisdiction of particular court, then that court will have the jurisdiction to entertain the petition. In this case, my lord,
Yes,
the petitioner's factory as well as the office. Factory from where the goods are manufactured and supplied
yes,
are within the jurisdiction of this report.
yes.
Now, before supply of the goods are inspected by the responding corporation in Guwahati. For supply of the goods are inspected. And that inspection is done at Guwahati within the jurisdiction of this report. The so-called notice which was issued to the petitioner, that was served addressed to the petitioner in Guwahati.
Yes,
The blacklisting order was also served at Guwahati. And the goods
yes.
which are manufactured in the petitioner's factory at Guwahati are supplied in pursuance to the tender to the places where the respondent corporation is acting.
So you don't have factories in any other place?
No. This order is only from Guwahati. Now, I take it off directly. A division bench decision of the Gujarat High Court,
Huh?
The division bench judgment of the Gujarat High Court on the same day need to issue, on the blacklisting itself. Territorial jurisdiction.
Whole bunch. Another thing. Other matter. I think it is. Yes,
But after discussing, analyzing all the Supreme Court decisions on the fourth election, at page paragraph 16 of the page 132,
132.
16,
132.
132. Correct.
Yes.
Yeah, correct. This is a blacklisting order, no? This decision obviously and invariably would have a lasting effect on the business, and the banning order, blacklisting order also would have a its echo in the business conducted anywhere in the entire country, so far as the ONGC is concerned. Moreover, the petitioner is operating from district Rajkot in the state of Gujarat. Not only the correspondence of the so-called notice and his reply within the jurisdiction of this court, the office is of the petitioner is a Rajkot and it conducts for all business purposes from Rajkot office. His order of banning was served upon the petitioner company at Rajkot would have material bearing on his future business. Not a small part, but a substantial part of the code of action arising within the jurisdiction of this court. Therefore, the contention on the part of respondent of that this court having no jurisdiction to entertain this petition to be no merit acceptance. As such contention is rejection, respondents have sought to drop the ratio account in the council for the reasons stated will not be. Now, the division bench of this honorable court will also at an occasion page 70.
Yes.
The comparison has to be given to my,
Ah,
the comparison of judgment must be given to my judgment also.
yes, you have to give.
That's where we have.
In fact, I noticed that it's not done here too often.
But we have made it particular
Ah,
time.
eh,
But in particular.
I remember in Delhi High Court and all, we used to always give the other side.
To be done at protested, what is the maximum fees to be done?
Wait.
In this case, the validity of the Maharashtra state lottery regulation rules is online. What challenge before this converter? Now, if you also make any similar, para 2 at page 72.
Yes,
The case of the rich petitioner is that the state of Arunachal Pradesh organizes lottery under the Lottery Regulation Act, and likewise the Maharashtra government also organizes lottery in their state. The state of Maharashtra, in exercising the power under Rule 18, Section 19 of the Lottery Conduct, frames certain rules, and Rule 9, according to the petitioner, places unnecessary restraint and prevents the petitioner from selling their lottery tickets in the state of Maharashtra and is therefore voiding the petition. So, the restriction was put by the state of Maharashtra, by the Maharashtra rules, and that was challenged before this on the court. And this on the court, Division Bench of this on the court, you'll have to find. That para page 78 below,
para.
para 70. I'm sorry, it's referencing para 12 below at page 136, 76. Para 12, page 7.
Page 76, para 12.
Para 12.
Yes,
It is production. In doing so, the effect for examining the constitutional validity of Section 5 of the Lottery Regulation Act, and it was returned for the provision Section 5 of the Act to strike the balance, and it was provided that the state should regular, restrict and restrain the sale of lottery tickets in other states only where the state does not run its own lottery. In the present case, there is no dispute at the bar that the state of Maharashtra do run their lottery, and as such, the state of Maharashtra, the state of Arunachal
Arunachal.
Pradesh and the state of Nagaland have the statutory right under the act to sell their lottery tickets within the state of Maharashtra. It is submitted that by the entering rules showing so, the state of Maharashtra is trying to put unnecessary restrictions as regards the entry and the sale of tickets in the state of Arunachal Pradesh and the state of Nagaland within the state of Maharashtra, and this is violate the right of the state provided in the act. It is further stated that printing of the tickets by the petitioner state and the organizing of the lottery is carried within the jurisdiction of this court. A part of the court of action has arisen within the jurisdiction of this court, and this court can entertain the petition. In also, this court held that even a part of the court of action has arisen within the territorial jurisdiction of the court, such high court shall have the jurisdiction to entertain the petition. Considering the pleadings and the relief sought for the petition, we hold that the learned single judge has rightly decided the question of taking jurisdiction in favor of the petitioner accordingly. We hold that there is no ground to call the petition to the ground of the petition. Now, in this case, my lord, the restriction was put by the state of Maharashtra.
And this act or the rule was made in Maharashtra,
Maharashtra.
and that was cut down here.
Otherwise, by this honorable court.
There is a single. Say what happened? Did this matter go to
No.
Supreme Court?
No.
It did not go to Supreme.
I will not go on the merits, my lord. I appeared on behalf of the state of Maharashtra in this case. In fact, I raised,
I saw your name.
well, I raised the plenary objections about the taking jurisdiction. But anyhow, that was rejected. But today it has come about these things.
It did not. This did not go to Supreme Court.
No.
This case.
I'm not on the merit whether they.
No, I just want to know because
No, it has not gone, below.
no, but anyway, do you think it's correct?
But so far as personally, you'll also see the question of that the rule of Maharashtra cannot be challenged before this one. But I am only on the creative jurisdiction, not on the rules of something. I am only on the, so far I am concerned, because I have never heard that rules framed by some other state is relative ultra biased by the High Court. That is on the merits. But the question is that here, the lottery tickets were printed in the jurisdiction of the court and were sent to the Maharashtra for publishing there. And this on the court held that part of the corruption had arisen within the jurisdiction of the court. Leaving aside the merit, I am not on the merit, but personally I am I am not satisfied that the rules of otherwise every state will start declaring the rules
Correct.
of other states to be ultra biased. And in my humble submission, that
That way, the GST of each state will have a problem. They're all interconnected.
but the GST, CGST, I can understand, but the state GST, if somebody files in Jammu Kashmir,
That's what I'm saying. The state GST. That's what.
it will have a, like that seizure is made, of the goods which are in Calcutta. Now, Guwahati High Court cannot declare that seizure to be illegal because that was done by the Calcutta authority and the petition has to lie there. Otherwise, if seizure is made anywhere, somebody files a petition anywhere, that is,
Okay, that is one. So even I'm bound by it, but
but I on the not on the merit, not on the question
yes,
of
yes, and
lottery regulation, whether it can be declared to enterprise or not. I am only on the issue of the territory jurisdiction. That when the tickets were going from here to Maharashtra to be organized,
but then the issue was the rule.
the rule I can understand. Rule was the effect. The effect was that the rule. We replace it by the rule, the blacklisting order. Where rule will not
Out
normally
there, the rule was under challenge.
rule was the challenge. But normally rule cannot be equated with an executive order. But here the statute rule was in the challenge, and this one of the court by after all, now this is the law of the land. So my submission for not to get
Okay.
that the blacklisting order has an effect on the supply of goods which are being manufactured in the factory with the taken jurisdiction of this on the court. The goods are to be supplied from a place within the taken jurisdiction of this on the court. All banning order and so-called notice were served to the petitioner at the Guwahati office. The goods are inspected in the Guwahati office. And as such, a part of the cause of action certainly has arisen in the territorial jurisdiction of this court. At the lordship knows, that the small part of the cause of action arises. We can take it to court, then the court will have the jurisdiction. Now coming to the suppression of the material fact. No, I will take a look directly to the effect from the exactly the same issue. Case 15. Where below a shoot was filed. And the requisition,
Is with regard to,
same matter, shoot was filed, and that was not disclosed in the requisition.
Yes.
Watch me see para 60, page 66, para 40. Para 15, 14, last 7 or 8 times.
Yes.
But where? But where on the right hand side? But where in the parallel jurisdiction?
yes, yes.
But where in the parallel jurisdiction, the order is not a speaking one, and the matter has been disposed of on some other ground. This court has, in a suitable case, entertained the application under Article 32. Instead of dismissing the requisition on the ground that alternate remedy had been availed of, the court may call upon the party to elect whether it will proceed with the alternate remedy or with the application of Article 236. Therefore, the fact that a suit had already been filed by the appellant was not such a fact that suppression of which could have affected the final disposal of the requisition or marriage. In this case, admittedly, the appellant had withdrawn the suit 2 weeks after the suit had been filed. In other words, the appellant elected to pursue the remedy only in Article 226. The pleadings are complete before the court. No doubt the interim order, which was passed by the court, was obtained when the suit was pending. But by the time the requisition was heard, the suit had already been withdrawn a year earlier. Although the appellant could not, on the High Court's reasoning, take advantage of the interim order, it was not correct in rejecting the requisition itself when the suit had already been withdrawn, especially when the matter was ripe for hearing and all the facts necessary for determining the requisition or merits before the High Court, and when the court was not of the view that the requisition was otherwise not maintainable. As the issue of suppression was the only ground on which the High Court had rejected the appellant's plea for relief, we would ordinarily have to set aside the order of the High Court in view of our finding and remand the matter back to the High Court for decision on the merits, but the matter has found to be argued on merits before hearing. Now, if you lost, if I just look at the order which the 512 from patient court, passed by this order court,
No, first of all,
I will.
what is the reason for the blacklisting?
So I'm coming to that, I'm coming to, I'm just,
Okay, you're just going to the preliminary objection.
because the preliminary objections will be raised, and normally, the preliminary objections have to be answered first. And then, I will come to the practice.
But I wanted to know the issue first.
Well, 100%,
You're taking me straight to the law point. I want to know the facts.
I will take a loss, the active focus now.
Yes.
And which you also find at page 339. Although this is voluminous, the point will be very short.
I hope so.
No, 100%, I can assure you like 6 words. Page 339.
So a good lawyer always makes it very short. and very easy to understand. Yes, page
339.
339. Yes,
If you lot permit me, I may read this one.
yes, yes.
You are hereby required to focus in writing within 10 to 15 days of the year, but why should one be placed on holiday leave and we depart from entering into the contract with BPCL for the following reasons. BPCL has plotted a tender number so and so, so and so. You participate in the same tender and submitted declaration towards the local content of the offered products to be 82.36% and claim purchase of the preference as per PPP May 2017 for being class 1 local supplier. So, my lord, the first thing they are saying that we made a declaration about the local content of the goods to be attributable so and so. Based on the bid submitted,
What do you mean by this local
local
content?
content is local, my lord, with
Local material.
local material, when made in India, my lord, that it must be local.
Okay. So the components of the product
I know.
should be 82% local.
No, not local. We declared that it is 82%.
Huh?
We declared that
82.
82%. Although requirement is
Okay,
that, although requirement is that 50% or more.
50% or more.
More.
And you declared 82.36%.
My lord, we declared 82%. We declared on the basis, my lord, that we purchased from in India. Now that goods, some portion of the goods were coming from outside India, were converted here and thereafter we purchased. Now we have taken it that when we purchase from the locally in India, then that is also local content. But that issue will not come, I take your lordship, that in the order, this issue is not there. Your lordship, I will just take your lordship. Although they have, so-called notice, they have taken the issue, but in the final order, this is not the issue. Local content issue is not
But
there.
that is supposed to be the issue.
My lord,
But that is supposed to be the issue.
but when we gave the reply, perhaps they were satisfied and dropped this issue.
That's it.
Hello. Based on the bid submitted, Messrs. So-and-so did not emerge as L1 bidder for any of the lots scheduled, but their course qualified the stipulation of being within L1 plus 20% bracket. They are eligible for purchase preferences under Make in India Policy 2017, subject to the confirmation of the matching the L1 date of the particular lot scheduled so-and-so was given an opportunity to make the L1 date for the full lot schedule of the tender under the said policy for which the agreed and 37.5%, 60% of the 75% of the tender quantity for the first four lots scheduled for the tender, total amounting to 15 crores 2 lakhs 76,140 so and so was awarded. So the system is that even if a person is L4, but if he is class 1, that is local content is more than below the 50%. Then
He'll also be given
he
the,
is given the preference subject to the condition that he must match with the L1.
Ah,
Rate.
ah.
So since
so basically it's a tender to get the minimum rates.
my lord,
It's just to get the rates, the
rate
fixed
is
rate.
rate minimum, but subject to giving the preference to the person who is making India.
Ah.
They have to give the preference.
So if they have crossed that 52% or whatever, then they all get
If more than 50%, then class 1.
last
1.
one.
Now we also as per the requirement of the above policy, you are required to submit declaration duly supported by the cost accountant certificate towards the maintenance of the requisite local content in the product supplied and every invoice in order to meet the trade requirement and the supply from you meet the stipulated local content requirement. Regular follow-up was done from end. You, however, initially submitted the same documents which were submitted in the bidding stage when advised to submit the documents on every invoice basis, while email dated so and so, you informed that your earlier submitted declaration of 82% so and so local content in so and so was not executable. It was further claimed by you that the products delivered had a local content of 51.45%. And thus you will still fall under the category of class 1 local supplier with local content equal to more than 50% of the PPP so and so. You have further mentioned that on the basis of the availability of raw material to meet the stipulated local content mentioned class 1 local supplier, you shall only be able to cater the first call of your requirement of BPC. So, we say,
Wait, what is PO?
purchase order, no? He said, in this case, what happened, Milord? The letter of intent was for 15 crores. Work order was issued for 12 crores only. Work order was not issued for 15 crores. So we said, we will be able to supply up to 12 crores. That was the submission made. Now, what's mechanism?
Is that in writing? That 15 crores per foot, that is an issue here.
I know.
That is an issue here, 15 crores per foot. Okay.
The issue is only about the quantity supply.
I know.
That is other issue are not there.
At the quantity, the supply,
Supply.
the 15 crores and 12 crores.
So that
It's not with regard to the makeup of the product.
no. In the blacklisting order, makeup of the local content issue is not there. Now, the issue which I will be taking the loss is that when 15 crores was the quantity LOE and the award was made for 12 crores and about 5 crores books only were taken. Rest still they have not taken it. Only 5 crores worth rupees are taken. And we regularly writing to them that kindly give us the dispatch order for balance 7 crores and something. That was not given. Now, without directing us to give the 12 crores is purchased, and they say supply 3 crores more, balance one. And I say that I cannot do it. You can initiate the proceeding. But on the hypothetically, when the quantity has not been ordered at all, and in spite of the quantity work order having issued, you have not purchased even 40% of the same dispatch order has not been issued as yet. 7 crores rupees goods have not been taken as yet. Can anybody say that because of the balance 3 crores, you said that you will not be able to supply? So we blacklist it. Following the contract at your loss reward, there must be first that you supply the balance one. I say that I will not be able to supply it. You can initiate the purchase. But you yourself, 12 crores rupees of goods work order was issued, you have not taken for 5 crores. And you are blacklisting me on the ground that you have submitted that you will be able to submit only for the first call of quantity. And I will take your lordship to that the order also. How that is a wrong order. That I
So you were supposed to supply 15,
LOA
Oh.
was 15.
but you can supply only 12 according to you.
Work order was 12.
Work order was 12.
12.
But supposing they gave you work order for 15, can you supply for 15?
If they say we'll supply, that stage has not come as yet. That stage will come only when they issue the work order for balance 3 and direct me to dispatch. I mean, even suffering loss, I will supply.
Okay, for this make in India, what is the percentage required? The
50%.
component?
50%. That means I'm so good. It's the close it. And as you also aware, that blacklisting order has a very serious consequence is said to be paid. The Supreme Court has said. I will show to you, Lord, demonstrate to you, Lord, that how, without application of the mind, the impending order will come. I will show to you. Demonstrate to you, Lord, that will be only by approach. You will also have seen, they say that I have said
that I will be able to supply only the first call of quantity, which is 12 crore. Profit is noted in it.
Where have you said that?
Well, your customer receipt, the order is 340.
Yeah.
The last line, you know.
Yeah.
Right, so and so. Further mention that on the basis of ability of raw material to meet the stipulated local content requirement for class one supply, you shall only be able to cater the first call of PO quantity to the beneficiary. First call of quantity is 12 crores.
No, but where is it that you supply only 12 crores?
You know, I said that up to first call of quantity, whatever is there, we will be able to supply.
You shall only be able to cater the first call
Call
of
of
your quantity to
quantity
be.
to the beneficiary.
So how much is this?
12 crores something. And I'll show you lots of room document that we never said that these 12 crores worth of goods will not supply.
So you have basically said that you can supply only 12 crores.
Up to 12 crores,
Up to 12, not beyond.
not one. Because Millot, you're also just work order was only for 12 crores. LOA was 15 crores. Work order had not been issued as yet. Work order was issued for 12 crores only. Now, Millot, in a case, somebody says that you supply the balance one. And I say that no, I will not be able to supply balance one. You can issue so called notice. I may say that I will supply the balance one. But when that occasion had not arisen at all, because you have given the 12 crores work order only, and out of that you have purchased dispatch order, you have given only for 5 crores. Something. And out of that 5 crores something order also, my lord, goods worth about 60 or 70 lakhs had not been taken as yet. From the dispatch also.
What does the tender say? What does the tender say?
Tender say 15 crores.
Oh.
LOA, no, they don't speak LOA is more than 15 crores.
LOA is 15 crores.
15 crores. Work order for 12 crores. Dispatch order 5 crores something, out of which about 60, 70 lakhs still dispatch orders have not been given. Still pending. So 7.5 crores worth goods still they have not ordered for dispatch. Now I take it also. Yes.
Yes, please.
Well, page 340, paragraph 2. This action of the Mukund client so and so tantamount to committing the breach of contract, having abandoned the contract, and thus would entail penal provisions of the holiday listing and official and also penal provisions, including the financial penalty listed in the clause 9 of the so and so, and the clause 9 is reproducible, that is they are quoted. Your reply should be submitted. So what action is to be taken? Clause 9, they are quoted.
Yes.
Now I submitted reply at page 20.
Page 20.
Page 341. And I checked.
Yes.
Let me take a look, see back in page 342.
May I read, my lord?
Yes, yes.
On subsequent interactions, specifically on so-and-so, when a meeting between so-and-so official took place in Mumbai, the subject issue was discussed in detail. It is in the meeting that we realized that the clause was capable of another interpretation, different to what we adopted by us. Accordingly, we submitted the letter dated so-and-so by BPCL informing that the BPS interpretation of the local content of the goods supply will be 51.45%. We informed BPCL our inability to meet 82.36% local content criteria and keeping in mind BPCL interpretation of the policy and on the basis of the availability of raw material to meet the class 1 local supplier local content, we informed BPCL that we could cater only the first call of PO quantity under PPP policy. The motion is finally noted.
So this also under 51.45%.
So 51.45%, we said that we, with this interpretation, we will be able to supply only up to the first call of quantity for the company. Now we'll also see, it is pertinent to state herein that although we did not match the requirement of local content as per BPCL interpretation, we were fully in compliance with the local content requirement as per enclosure 1 of the subject policy in table 2 for the supply content, that is class 1, 50% or more. So we said, that even though it is not 82%, but it is 51 points showing for the which is in terms of the class 1 criteria, that is 50% more. Now we'll also make a similar. Response to point number 2, it is not in dispute that the declaration of 82% local content was initially submitted by us. We have given declaration of how, why the 82% was given and why it has come to 51%. Now I will take you directly to the logic to the blacklisting order.
Yes.
At page 372.
Yes.
You will also see first paragraph, where a proposed notice was issued, you can execute purpose.
Yes.
Therefore, you subsequently revise the local content in key pipe intended to be procured through the tender so-and-so and reaffirm that you will be able to cater only the first call of quantity to BPCL. It may be noted that the first call of quantity works out to be 75.87% of the total award value. That is 12 lakh crores and 15 crores. Now you're also getting. Hence, it is customary that Mukund Plywood Limited is unable to supply balanced quantity equivalent to 24.13% of the total award value of the contract document so-and-so, supply the full quantity awarded under the said contract. So they say we are not in a position to supply the total awarded value. Now we'll also see. With reference to the commercial penalty available at PPL policy, you have submitted that the penal provisions of so-and-so do not apply as you claim to have not violated local content because you would be so-and-so. Above, it is noted that against the fulfilling of the contractual obligation of supplying 12 crores 72 lakh something. So what they are saying, that contractual obligation was to supply 12 crores something. You know what I'm talking about? Now they are saying that it is clear that against the fulfilling the contractual obligation of supplying 12 crores 72 lakhs 53,315.30 worth of so-and-so pipe against the contract, so-and-so message so-and-so had encompassing implied that they shall not be able to supply materials worth rupees 3 crores something against the contract value, which works out to be 24.13% of the awarded value. Now, this 24.17% is the percentage of 3 crores to 12 crores.
It is the remaining 3 crores.
Well, remaining 3 crores, I never said that I will not supply 12 crores. Now they are saying that out of the total awarded value of 12 crores, they are admitting that it is 12 crores only. Out of the admitted 12 crores something, I will not be able to supply 3 crores. Where I've said? This percentage which has been worked out below 24.1% is 3 crores to 12 crores.
No, it's 347 lakhs.
My lord, if 3 crores 7 lakhs, percentage of 12 crores, it comes to 24.17%. So they are taking that 12 crores is the awarded value. And I have said that 3 crores I am not supplying. I have never said. I've said that 12 crores goods I've supplied. Because my lord, if the percentage is taken to 15 crores of 3 crores, it comes to 20.45%. But they are not taking of 15 crores. They knew very well that we have not awarded the supply order for 15 crores. Now they say that 12 crores out of that 3 crores I refused. I've never refused. I'm always saying that please take this 12 crores. I will show to you also the letters that place orders, give us the dispatch orders. They are not giving the dispatch order.
Let us see your agreement.
You know,
Your agreement.
agreement. It starts loaded case. Eh? Huh? Melody is case 52.
This is NIT, 52 is NIT.
My lord. I will also make see page 86. Lord, clause 8.
86, there's no clause 8.
Clause 6, I think 6 is good. I'm sorry. It is 6 is good. Delhi. Delivery shall be done within 12 weeks from the date of purchase order, letter of intent. The date of receipt of material site shall be considered as the date of delivery. Now it was to be done within 12 weeks. Now, not to speak of 12 weeks. They have not placed the order for full quantity. They have not given me the dispatch orders. Can anybody say, my lord, that in we will violate the provisions of the tender document, will not place the orders for life to come, years to come? Your obligations will remain. On the one hand, you don't follow.
Where is the agreement, first of all?
My lord,
Agreement?
agreement, the order which has been passed by LOE,
Page 150, madam, there is a format of agreement.
Page 150. 115 or 150?
150.
You can go.
And LOA, मतलब that page number मतलब 216.
216 is a little bit. Two 216 no letter of acceptance. You have to find the total amount mentioned at the bottom. In the first column at page 230.
1, 3.
230.
What is this?
You know, the first column,
All off.
you know, the purchase order, you know.
Okay.
And all subsequent documents related to purchase orders are emitted from page 232 onwards. And
But where is that word call off? It is not here.
you'll also find. Look. At the second line, we are pleased to issue the call of one.
Okay, call off one. Yes. All different terms. Why don't they say purchase order number?
Well, generally, I have also come across first time. But this was the letter of acceptance was 15 crore. The first call off was for 12 crore something. And thereafter, the dispatch order. You'll also find at page 282. And the amount comes to 5 crore 50 lakhs 62,300.
Where do you get this amount?
Amount is not mentioned here, the quantity is mentioned.
This is for how many? This is for 5 crores.
5 crore 50 lakhs 62,300. Now, although the dispatch orders were given for 5 crore 50 lakhs, but the destination has to be given. Where it is given. That also were not given for full amount. Near about 60 lakhs rupees of this one also, the goods have not been able to supply. And we have specifically given the letters. You will also find the letters at page 269. You'll also find the chart below.
269. Yes.
269. 369 for the notice. I'm giving you the receipt.
No problem.
369, no?
Yeah.
So now see the second number, total LOA quantity. You also got it?
Yes.
Then first call of PO quantity, it is mentioned here. Then first inspection calls, it is mentioned. Dispatch against first call inspection is mentioned. Balance to dispatch against first call inspection. This is the quantity below, which despite of the dispatch order had not been below the destination of the not been given. And balance inspection call to be raised from first call of, which is last. And what we have written below in the letter, further you are yet to raise inspection for the balance quantity, call of PO quantity, please refer column number so and so. So it is kind request to give us the clearance for dispatch of the quantity mentioned in column number G. G means the first call of and whatever quantity the inspection has been done.
Anyway, so that is okay. So basically, the letter of acceptance was, the contract was for 15 crores.
I know.
Now, according to you, you are saying that you have never taken a stand that you cannot supply the 3 crores.
We never taken the stand that first call of quantity.
Ah.
We will not be able to supply. Since the work order is only for 12 crore, the 3 crores question will come only when you issue the work order. The work order has not been issued as yet. And the blacklisting order says that I have said I will not be able to supply the awarded value of 12 crore, which is absolutely perverse, incorrect. If you proceed on the wrong facts, wrong assumption of the facts, and pass a order which has a serious consequences, blacklisting order.
So you say that there is no work order for 3 crores.
My lord. Their entire assumption is that, my lord, that out of 12 crores, 3 crores I will not supply. Which is prima facie incorrect, on the wrong facts, and a blacklisting order can be passed. On the basis of the wrong assumption of the facts. I'll place before lordship one judgment of the appeals court only.
So basically, the thing is that whether it is a wrong assumption or not, that is the only thing that has to be seen.
The blacklisting the appeals court has said that you must point out that what is your fault.
Yeah.
What is your fault and what punishment you are going to impose. It must be clear. It cannot be vague. And place only one judgment. If you proceed on the wrong facts, not in any case, not only blacklisting, any order, as you also be aware, that if any order is passed on the basis of the wrong assumption of the facts, then the order cannot stay.
So we'll have that issue, we'll see.
Well, certainly,
So that is a basic case.
basically, I take
Your basic case is that you are willing to supply 15 crores, but since there's work order for only 12 crores and no work order for the remaining 3 crores, the question of you not supplying the balance 3 crores does not arise. And accordingly, the assumption made by them or the reason given by them for blacklisting you is on assuming that you have taken a decision that you will not supply beyond 12 crores.
I something although you must not been very small, but I could submit.
No, that's what you have said. Yes.
What I was telling you, sir,
Huh?
even for the sake of repetition of
Yes.
that unless and until you give me the order
I know, and that's what you said.
and you ask me to supply and I refuse, then issue is so forth.
But one thing they have mentioned in their so-called notice,
My
And even that something about that PO, the first PO.
Well, they are saying PO, but you also that is so-called. You'll also have to see the final order. The blacklisting order which has been passed. The blacklisting order has been passed on the ground that the awarded value was 12 crores. And I have said that 3 crores I will not be able to supply. And they have taken the percentage of 3 crores to 12 crores. If their intention was 15 crores, then the percentage would have been 20%, not 24.17%. So they have not taken 15 crores. And in any case, 15 crores they cannot take, because unless and until you place the place of the work order and ask me to supply the goods, only on refusal to supply at that stage,
Just come again on that 20% and the 24%.
my lord, you'll ask me see in the order, blacklisting order, my lord. At page 372.
Yes,
Well, they mentioned the percentage. 24.13%. This percentage, if you also calculate it, it is 3 crores to 12 crores.
3 crores to
12 crores. 3 crores of the percentage of 12 crores is come to 24.17%.
so it is not on
15 crores.
15 crores.
So 15 crores, if we calculate it, my lord, it comes to 20.45%.
20 point.
45%. So you have not considered the 15 crores at all. You are proceeding on the basis that it was 24 point something. Now in the affidavit of position loss, can you see, my lord? I am surprised, my lord, how the affidavit of position my learned friend has filed. His running page is 411.
Yes,
Second paragraph. It is submitted.
yes.
It is submitted that petitioner supplied only 75.87% of the awarded quantity. Where? Who is supplied? You have not given me order for 5 crores only, and you are saying that they have already supplied 75.87%.
No, they give you supply order for 12 crores.
You also see, it is submitted, the petitioner has supplied.
Only 75. 75.87 of the 12 crores monthly.
That also, how it can be? 12 crores, only 5 crores worth of dispatch orders were given.
You said 12 crores.
My lord,
12 crores worth
12
12
crores
crores.
also be
Work orders given.
5 crores if you take the percentage. It will never come to 75.87%.
This is some calculation missing.
No, Lordship, further similar of the awarded quantity and due to non-supply of the remaining quantity, the deponent corporation suffered loss. How? Out of 12 crores, you have placed dispatch order for 5 crores, and you have said that they have suffered loss because of non-supply. Well, the opposition cannot fight so lightly by the corporation like the big, this is big corporation. You want to kill me and kill me also on the basis of the wrong facts
Is this dispatch order is issued by whom?
by the corporation.
So it is only for 5 crores.
5 crores something, 5 crores 50 lakhs, and out of that also, the dispatch destination has not been given for 50 lakhs something. Still, the books are lying. So I forget about 15 crores.
For 50 crores.
I forget for the time being, 12 crores is here. You say that you have suffered from the supply. You are not purchasing. How you are suffering? You yourself are not taking. How they are suffering? In fact, I am suffering. You were to take the goods within a particular time limit. For years, you will not take the goods. And you will say that you have to remain bound for years to come. We may say any time, otherwise we will blacklist you. That's why, Milord, on the earlier occasion when it came, I said that, Milord, it is because of the competitors who wanted me to be out. Because I was L1, so they want that the L1 I should be blacklisted, letting me out. It is only by the protection given by this honorable court that I am surviving. Now I take your lordship to the judgment, one judgment of the apex court.
How long will it take?
Lord, I will place the judgment and thereafter, after hearing it, if necessary, I will.
The protocol won't take long.
But actual main points were two only, was suppression and technical jurisdiction. Okay. So I'll take a lawsuit to judgment at phase 1.
Yes.
And relevant paragraph at page 13. Page 13.
Page 13, Tara.
Para, my lord, 12. It will start from page 6, sorry, it starts from page 6 and relevant part at page 12, 13. Page 1, some other judgment is here. So it starts from page 6 and relevant part at page 13. Paragraph 12. 13, paragraph 13.
Yes. Para 12 is the
13 below. 13. At the outset, it must be noted that it is the first principle of civilized jurisprudence that a person against whom an action is supposed to be taken or whose right or interest are being affected should be given a reasonable opportunity to defend himself. The basic principle of natural justice is that the party a notice of the case against him so that he can defend himself. Such notice should be adequate and grounds necessitating action and the penal action proposed should be mentioned specifically and unambiguously. An order traveling beyond the bounds of the notice is impermissible and without jurisdiction as it stands. Causing here, Milord, the last thing in the proposed notice. It will mention the penal provisions clause 9. Now, in the order, that clause 9 is not there. This court in so has held that the essential for the notice to specify the particular grounds on the basis of which an action is proposed to be taken so as to enable the notice to answer the case against him. And so, specifically in the context of blacklisting a person or an entity, an unambiguous so-called notice is particularly crucial due to the several consequences of blacklisting and the stigmatization and accused to the person, entity being blacklisted. I may not skip over and may come to the para 16. The severity and effects of blacklisting and the resultant need for strict observance of the principle of natural justice before passing an order of blacklisting were highlighted in so. In the quotation portion, I will take you 15. The blacklisting order involves civil consequences is cast a slur. It creates a barrier between a person blacklisted and government in the matter of the transactions. Velocity para 18 below. This court in so has described the blacklisting as being equivalent to a civil death of a person because blacklisting is significant in nature and debars a person from participating in the government tenders, thereby precluding him from award of the government contract. It has been held thus, in common sense, the parties that the blacklisting has to be preceded by proper notice. Law is not so, makes people below. Thereafter, law is similar. Para 20. In the present case, the factum of the service of proper notice that is going to by the corporation upon the appellant is not in dispute. Rather, what Mr. Banerjee argued on behalf of the appellant is that the conditions of the said proper notice were not such that the appellant could have been anticipated that an order of blacklisting was being contemplated by the corporation. In the case where the government court has to decide whether the action of blacklisting could have been taken without specifically proposing contemplating such an action in the so-called notice. For this purpose, this court has laid down below the guidelines as to the contents of the so-called notice pursuant to which adverse action of blacklisting can be adopted. The central issue, however, pertains to the requirement of starting the action which is proposed to be taken. The fundamental purpose behind the serving of so-called notice is to make the noticee understand the exact case, precise case set up against the appellant. I may see the last paragraph is in the document, paragraph 22. We are of the opinion that in order to fulfill the requirement of the principle of natural justice, a so-called notice should meet the following two requirements. Number one, the materials grounds to be stated which, according to the department, necessitates an action, particular penal action which is proposed to be taken. It is this second requirement which the High Court has failed to
Which paragraph are you reading?
well, at page 16. Just last, but
No.
page 16 of the next page, no? In the beginning, you also find contempt of the so-called notice.
Yes.
And then in the bottom below, after completion of the paragraph, below, we are
Yes.
of the opinion that in order to fulfill the requirements of the principle of natural justice, a so-called notice should meet the following two requirements. The material grounds to be stated which, according to the department, necessitates action, particular penalty action which is proposed to be taken. It is this second requirement which the High Court has failed to omit. And also, paragraph 21 at page 562.
Yes.
17 or page 17. Thus, from the above discussion, a clear legal position emerges that for a so-called notice to constitute a valid basis for blacklisting order, such notice must spell out clearly or its contents be such that it may clearly infer therefrom that there is a intention on the part of the issue of the notice of blacklisting the noticee. Such a clear notice is essential to ensure. Now, what so-called notice you have issued? You issued me so-called notice mainly on the ground of the local content. And while passing the order, you are going into the issue of the supply order. And supply order also, that too on the wrong footing. In the so-called notice, you mentioned that the penalty under clause 9, you have reproduced. Now you have given a go-by to clause 9 in the blacklisting order.
Blacklisted is included in 9.
The blacklisting order, but clause 9, you lost me see.
Yes.
The clause 9 they have quoted.
Yes.
In the so-called notice, Miller.
Yes.
Now that so-called notice in the final order, 9 is not there.
Doesn't have to mention. There's no requirement of mentioning.
In the Supreme Court has said that you must mention clearly what penalty you are going to impose.
No, but in the show cause it is there. Is it in the, is it here in the penalty, is it required?
You lost me see. The second part, note, particular penalty.
That is in the show cause. Show cause.
Show cause.
It's only in the show cause. It's not on the penalty.
The so-called notice, it must indicate that what penalty you are going to impose.
It is there in the show cause.
In the so-called, they are saying about clause 9,
Clause 9.
but in the final order, clause 9 is not there.
Clause 9 is not mentioned. That's all.
Clause 9, whatever mentioned below the penalty is there, that has not been imposed at all.
Blacklisting is there.
Blacklisting is there, no, that is a common one. That is a common one. But you propose to impose the financial penalty under clause 9. And in the final order, that's why the Supreme Court said that it must be clear and unambiguous. You cannot table beyond the so-called notice. So-called notice was not on the ground that 12 crores quantity you are not supplying. Final order is that 12 crores out of that 3 crores you are not supplying. It goes beyond the so-called notice. No so-called notice was given to me that out of 12 crores, 3 crores you are not supplying. I could have given a reply. The lordship gave Milord that Mohinder Singh Gill, that Milord, the order has to be examined on the basis of what is there. That he says, Milord, the wine does not become, as it gets order, the wine doesn't become better. So one cannot have an affidavit or something, you cannot improve it. It has to be examined on the basis of the order which has been passed. And about the so-called notice, one cannot go beyond the Milord. I've given in the compilation, I'm not talking, Milord, say that so-called notice, you cannot, order cannot go beyond the so-called notice. On the so-called notice, your contention was that you have contended that out of, you will be able to supply only the first color quantity. And in the final order, you are saying that I have said that I will not be able to supply first fruit. You know, going beyond the notice. My humble submission, Milord, is a clear case of non-application of mine by passing such a serious order, which amounts to civil death. You know, when the death penalty you are also giving, even a small, reasonable doubt, the death penalty is not given. So, Milord, I have given the liberty to right.
So, but not for yes for who?
For the teacher, for
Mr. Roy, you're there. Also. You're with him, meaning you're for the same party.
he's for a,
No, Mr. Convoy for you.
I am for respondent to my left 6.
2 to 6.
Any Patak,
Ah,
any Patak,
yeah.
I go by the response. Sorry, it is a mixture. Kindly see my left, where the thought of it. Trying to write up action and the thought of action. That is not the is not. It's not write up action, not that thought of action. Thought of action, rules my left, the Maharashtra only.
So, what is this service of notice gives him the right of action?
Right of action. I'll certify. The everything was done at Mumbai Met. It was nothing was issued from Mumbai Met. The training order was issued from my left Mumbai Met. And then nothing was issued from my left Mumbai Met. We meeting was held in Mumbai Met. Our next morning was deposited in the bank of my left Maharashtra. Everything was happening in Mumbai Met. Here, my left, having the registered office of the company, that's not yet for the. So I'm directly relaying on full bench as well as Kerala High Court. Full bench as well as Kerala High Court. Where it depends on right of action and the author action.
Sometimes when I lose the case, so I can declare the state of Maharashtra. I was declaring the state of Maharashtra, I lost the case. Now I feel that losing the, in that case, was not bad for me, that was state of Maharashtra. And they have not challenged it in the state court. They have not challenged it.
There must be something in this.
Yes, madam. I have a judgment, madam. Still judgment.
You got a judgment. There must be something in the Supreme Court.
Hey, nothing in the picture, you know.
Kerala judgment.
No, lottery is there. And lottery, you're not.
In the lottery,
How it
madam.
happens. There are various factors are there.
Sikkim, madam.
For not challenging and these things, there are various factors are there. Lottery business is very dangerous.
I know. So you are appearing for the lottery people.
Hello?
You are appearing for state of Maharashtra. You are
State of Maharashtra, I appear, you know. And I try my best, but
I appeared for some lottery companies earlier. Long time back.
The para 19, madam.
Huh?
Para 19, madam.
Para 19. Yes.
He started what really arrived. There's no question.
Yeah.
What really arises for decision is whether the fact that on communication of the order is become effective as far as the person is concerned in the right to approach the court for a fact.
Oh no, where are you?
There are 90 minutes.
Para 18 from 19. कुछ तो mean what?
What really arises. Can I?
Huh?
There are 2, 3, 19 there.
Or 2, 3, 19 are there.
इंटरप्रेट मिला तो वन फुल पे अर्लियर फुल पे जाते ना का कहला है को रिचल में सब what really arises for decision is whether the fact that communication of the order is done effective as far as the person is concerned within the right to approach the court for which is really a fact, which is part of the bundle of facts that constitute the cause of action. It is well recognized that there is a distinction between the cause of action and right of action. The right of action is also, although the court sometimes confuse the term cause of action and right of action and states that the right of action law arises from the existence of primary rights in the plaintiff and extinction of the right by the from the on the part of the defendant in a legal sense. These terms are not synonymous or interchangeable. A right of action is the right to presently enforce a cause of action, a remedial right, including redress for the extension of their rights coming to some definite person. A cause of action is the operative fact which gives right to such right of person. Right of action does not close until performance of the sufficient precedent to the action and may be taken away by the writing of the institute of litigation, so in fail or by other circumstances which don't affect the cause of action. There may be several rights of action and one cause of action and rights may be to suspend and of the same person. The above extension was referred to by students of Allahabad according to so their lordship held at the terms of cause of action and right of action are synonymous. Right of action is the right to presently enforce a cause of action and the right according to the constitution of the right from the person. A cause of action is operative fact which gives right to such right of action. His lordship justice so adopted the same approach and noticed the distinction between the cause of action and right of action. In so and so, the individual bench of the Allahabad High Court held that right of action is the right to enforce a cause of action. A person residing elsewhere in the court country being achieved by an order of the government, central or state authority or a person may have a right to action
at law but can be enforced or jurisdiction under 220 of the 226 can be invoked of the High Court only within whose created limits the cause of action wholly or in part arise. Cause of action arise by action of the government or the authority and not by residence of the person aggrieved. In a case when officer in the Indian Air Force was superseded when he was posted at Madras, he sought a direction by filing a requisition in the High Court of Allahabad to command the appointing special decided requisition by him. It was held that the High Court at Allahabad had no jurisdiction since no cause of action arose within the jurisdiction of the High Court at Allahabad, who should entitle that officer to approach the High Court at Allahabad. Direction was sought to be authority whose office was situated in Delhi. Following this decision and referring to the earlier decision on the subject, another decision bench of the Allahabad High Court in Benzo held that illegality in the award of complex station outside the jurisdiction of the High Court of Allahabad would not entertain in the High Court of Allahabad merely on the ground that station where the complex was to be performed fell in the jurisdiction of the High Court of Allahabad. In a recent decision on the Supreme Court in Benzo, Supreme Court held that in a case was registered and paid violence that is the respondent at Ranagar to come and to see the CBI at Bombay on the 60 at Ranagar does not compare to decision on the High Court at Guwahati at Benzo. If the person took was the first information report, both took the view that receipt of information by a active person that he should meet the concerned respect. The receipt of information by the active person that he should meet the concerned inspector at Bombay does not enable that person to approach the High Court. He has a reason for the communication. It appears to us that decision is so and so and decision on the Supreme Court in the depth of the High Court subsequent there to clearly establish that the receipt of communication by itself does not constitute a fact in bundle of facts constituting the cause of action. At case receipt of order or communication only gives the party a right of action based on the cause of action arising out of the action complaint of. When that action complaint of takes place outside the territorial division of the High Court and appeals thereof by an authority located outside the division of the High Court. Cause of action only arises outside the jurisdiction of the High Court, and if prove the conviction cannot be invoked to sustain a request in the High Court on the basis that a part of cause of action has arisen within the jurisdiction of this court, merely because the appellate order communicated from the seat of appellate authority was received while petitioner was residing or working in the jurisdiction of this court. Acceptance of the argument that the status of the receipt of the order will determine the jurisdiction can reach to position where a litigant in a position to show his own court for the purpose of redressal of his defense. All that he needs to do so to move over to a particular place for seeking communication from the authority that enforce the High Court of that the plea that the court has jurisdiction because the order available was served on him while he was residing in the jurisdiction of the High Court. No litigant can have a right to sue the court for seeking relief in a mere intervention of court for the position. Now it is now settled that after decision of the Supreme Court in 22, when there is an appeal against the opposition order,
But that is with regard to arbitration. Right,
yes,
when there is no, when the title has not been provided in the clause, agreement clause, then the cause of action will determine where the arbitral agreement can be. Or if they are two, places where the cause of action arises, then either one.
petition, but there is here is statement that the cause of action arises in the
So the receipt of the notice cannot be said to be a cause of action.
There are 21. It is now settled after decision of the Supreme Court in 22. That when there is a appeal against the opposition order, when the arbitration to
agreement to the appeal was withdrawn by the petitioner. That order was also published from by.
There's an appeal provision.
Yes, madam. They relied them on our policy also.
Just 2 minutes.
There are 21, madam.
Yes.
There are 21, madam.
How many paras are you going to read?
20 and 22, madam.
22. Why don't you give me a list of what has been said there? Para 21, 22.
But he says, madam, the mere receipt of the order.
Huh?
Mere receipt of the order, madam. Order from outside inspection, madam. Will not, madam, create a further action. Particular, madam.
So that is being reiterated
Yes, madam.
in all those paragraphs.
Friends, it's the right of action and the cause of action.
So right of action and cause of action are not interchangeable.
And he says, madam, the pleaded case there must be a pleaded case that the cause of action arises. There should be a bundle of facts, madam. There should be a pleaded pleadings minor implication.
Okay, that is on one aspect. What about
That
the
is not there,
aspect?
madam.
Huh?
That is not there, madam. When the cause of action arises, madam, because of that particular reason, that is not there in the repetition, madam.
Huh?
The petitioner should have, madam, pleaded in a repetition that for the reason, madam, the cause of action arises. That statement of the petitioner is not there in the petition, madam.
That?
That pleading is not there in the repetition.
Okay, that's the
Okay, madam, there are 20 and 22, madam. Then, madam, internal, madam, paragraph 27, madam.
of the same judgment.
Yes, madam. 27 and 28.
Huh?
27 and 28, madam.
Is it on the same issue?
Yes, madam. On the
Then why you want to go over and over again? Why don't you give me in a bunch instead of one by one? How many judgments are you relying upon? How many judgments are those?
5, madam.
It is three. Is it on the same point, all 6 of them, or different
The
different
last
points?
one is for madam, suppression material type.
Okay, now which one do you want?
That is mistake, madam. The facts has been elaborated in paragraph number 2, madam.
Which judgment?
The set of Goa versus Sumit online taking
Yes. Para?
paragraph 2, madam. According to the appeal and notification issued under
Para?
paragraph 2, madam.
2. Yes.
According to the appeal and notification issued under the state by
Little louder, can you read slightly louder?
according to the appeal and notification issued under the state by state legislature company subject to the restrictions in the section of High Court of a defined date
more so when no further action has risen in the decision of the High Court. It was further pleaded that since no further action or invocation or revision have arisen within the territorial limits of the High Court, the decision ought not to be proceeded.
No, that is the law.
Yes.
That is the law.
Yes.
Well, no, now he's saying that one is the notice, one is his factory or whatever is here. What have you got to say to that?
Goods manufacturing supply.
Huh?
Goods manufacturing supply from.
He's saying that his goods are manufactured here and will the delivery, the supply will start from here. What do you have to say to that?
There is a judgment of Utpal Kumar matter of the Supreme Court has.
So this judgment Goa is not required.
Issue from paragraph
Huh?
14, 15, minus 16,
Yes.
and 17 minus.
Yes, what does it say?
Is given the interpretation of cause of action, how it has come by
Okay, 14, 15, 16, 17.
17
14 to 17.
and 21 minutes. The Supreme Court
It's again on the issue of receipt of notice.
and the Supreme Court invoke the doctrine of a forum container.
Nice.
Paragraph number 20.
Huh?
Paragraph number 20. How it spoke. So 1984, 4 SCC 7. Yeah. Given the petitioner,
Tara?
para 6, 6, 11, 14 and 15 minutes.
So what is the issue here?
But here the petitioner there is the company of the registered office of the petitioner from there is
Yeah.
was Calcutta money and not the and NIT was issued from Delhi money. Yeah, so you say the tax has been received from Delhi money, Calcutta money. That's why the petitioner wrote up the Calcutta High Court. Because there is a it was a cost matter.
Huh?
It was a cost matter. Paragraph 15 minutes. At that time, 50,000 has been enforced by the. Attendee for. Paragraph 12 is important.
Yeah. Paragraph 12 is important. What does it say?
So he advised them on all handbooks. This kind of
What kind of petition was it?
no further action arises within the midst of the High Court. Very minor.
How does the fact of this case, is it similar to the fact of this case?
Here also, my lord, the petitioner, my lord, participating in a tender in Mumbai, on the of your own qualification.
Then
After my and the here, my lord, the Calcutta case, my is NIT was rejected, my. Communicated from Delhi to Calcutta. On that scenario, my lord,
so he challenged it in Calcutta.
yes, sir.
I'm reading that of मतलब the Bombay High Court मतलब from Nagpur bench तक the different bench मैंने पढ़ा पहले से मतलब महाराष्ट्र स्टेट पावर जनरेशन मुंबई लिखते हाँ ऐसा आ रहा था मतलब नागपुर बेंच मेरा ये पेरा फोर मैडम is going to learn a concept for a response in support of the preliminary operation submit the entire tender process to be conducted online and consideration of all fees received is to be undertaken at the head of the supply. The evaluation as well as the process of reverse bidding will also to be conducted online through the head office at Mumbai. The mere reason that transportation of coal to various thermal power stations, including those situated within the jurisdiction of his ban, cannot result in give rise to any cause of action to the to challenge the tender documents on the ground either in the requisition. Here, cited office of the is not sufficient to enable the requisition to be filed at Nagpur for being entertained on merit. Support to be sufficient. Here, submission of the online tender documents on a Nagpur would not does not comply in technical decision for the business to invoke the participants. It does submitted that since no part of further action has been just to be entertained in merit participants. Now, my place, both observation, my paragraph, my 7, 7, 8, 5. Paragraph number 7, madam.
Yes.
Firstly, madam. Firstly, it is to be noted that there is no pleading whatsoever in the entire petition to indicate the basis for petition to invoke the territorial jurisdiction of this court for seeking the relief sought in this petition. The grounds raised in the petition relates to the arbitrary manner in which the respondent conducts tender process, especially by setting the time for submission of this form to 20% manner. Contrary to the terms of the notice inviting fees, the restriction is clearly silent on the aspect when a part cause of action arise in the judicial limits of the Nagpur bench. The learned counsel for the applicant was rightly invited our attention to the decision on the Honorable Supreme Court in 22, wherein aspect of the imposition of leading facts to indicate the manner in which the cause of action arise has been highlighted. In the absence of any pleading whatsoever in the regard, it would not be permissible for the court to proceed merely on the assumption that since the petition has its officer Nagpur, the same is sufficient to improve the decision in the ground that a part cause of action arose at Nagpur. Absence of these basic pleadings to the petitioner from taking consideration of his contention that a part of cause of action has arisen. The petitioner also there are hardly any pleadings by afraid of people. The perusal of the e-tender document indicates that it has been published by the respondent Global Authority, but all steps commencing from a registration of the prospective sale tender document posting of meeting, followed by fair process still obtaining of access to be conducted at the office at Mumbai. It is true that certain acts are the submission of tender documents of the council that are participated at time. Merely because the petitioner who has the office at Nagpur has downloaded the tender document Nagpur and has sought to be approved by tender document from then it must be sufficient to convert the three part of conservation having arisen here. In fact, the petitioner could not upload the entire document for the file of so and by interim order the request for to submit the applied. It is stated in the paragraph 10 number it under the person that the petitioner submits is offline at the head office of the exponent by thus in the last fact even the petitioner bid document was submitted in Mumbai which indicates that not
no event has occurred in Nagpur, but I actually by the extension time for online submission of this, at least to be done to by other bidder. The extension of time from so and so has occurred at head office in Mumbai, when the fact that exploitation of road whole at some thermal power station with it in the basis of this is not a relevant factor at this two mention is of time for submission of it with the
Mr. Council, please, keep on reading, even I can read. You don't have to read the entire thing, just show me the important part. Otherwise, you're wasting time. See, one thing is the issues, the facts narrated by the petitioner's counsel. Let's go down to that. That issue regarding the fact. What do you have to say when he says that clause 9 has not been mentioned in the blacklisting order? It's been mentioned.
the last one of them I with the paragraph.
Huh? No.
No, only the paragraph number, but
Huh? Okay, give me the paragraph now.
2004
Um,
SSC minus 254 minutes.
Huh?
2004 6 SSC. So
2000?
4 6 SSC 250.
Yes.
Paragraph number 6 minutes.
Yeah.
6 to minus 6 to 18 minutes.
6 to 18.
Yes, madam.
Paragraph.
Small paragraph, madam. All your law, everybody should be going other things like happy.
Online has made life SCC online has made life miserable. Click and print out or
I'll go to the under aspect. Because there is a suppression of mistake back. But if you go by the judgment or indictment by the without any. Only see. The judgment or indictment by the student. Student 47 SCC 150. But he has not read the paragraph number 13.
Of
It says, madam. So here,
how long will you take?
definitely, madam.
Huh?
All expected. So it's a forgiveness, madam.
No, I'll give you time. But if you're not going to complete, I don't want to. We can always do it some other day if you're not going to complete. But you tell me, yes, this which judgment are you talking about?
Okay, S says the S business at private.
SJS, yes, SJS,
पहले से paragraph number 13 madam.
that is. Page,
Page 173 madam.
okay, yes, okay. As a general rule.
Yes, madam.
Suppression of fact.
We start from what the surface with marking material one.
So you're talking about, then you'll go to KD Sharma most probably after.
Yes,
Huh?
madam. From 34 to madam 39 madam. It says by it's a continuous cycle.
So I should stop examining this matter. That's what it says. Anything else?
So but the holiday list is a part of a contract madam. It removes the madam clauses of the holiday list policy madam.
Show me.
Yes, madam.
The page 81, my lord.
Page 81. Yes,
Policy on holiday listing, the guidelines and the procedure for holiday listing are available separately in detail website.
the guidelines and procedures for holiday listing and here.
The procedure for holiday listing are available separately in digital website and shall be applicable in the context of all tenders floated and considering all bidders complete the purchase order can be during the procedure. Now, the last and next time, page 374, madam.
Yeah. No, what do you want to show me
I
out here?
want to show my, it's a part of my contact, my, he relied the my policy, of our policy, my love. He prepared an appeal, my love.
Okay.
And when we have filed my love, affidavit, and on the first day, on 5/1/24, when we raised the issue, my love, then he withdraw the appeal. This is not a my love, suppression of material fact, my love. But on 18/12, it was filed, my love. Affidavit was shown on 18/12, my love. And on the same day, my love, the appeal has been prepared, my love. And when being on record, my love, the appeal prepared by the petitioner, my love. Thereafter, on the 8/2/24, my love, we have filed a affidavit of opposition, my love. Thereafter, they have withdrawn, my love. It means, my love, he admitted his guilt, my love.
Yes, at page 375 what? What do you want to show?
And appeal is at my love, the appeal provision is at my love. Page 381, my love. And my love, if petitioners, my love, pleadings, well, paragraph 39, my love. That the petitioner have not filed any other petition in any court of law on the same cause of action. Is a policy statement, my love, that
Court of law. Appeal was filed before a court of law.
maybe, my love, we pleaded, my love,
Where?
in our practice, we.
No, no.
Now, I keep missing that.
So he has taken care of that aspect.
And paragraph 38, but he says that there is.
Okay, then show me 381. Yes, 381. Yes.
In paragraph 38 also, he says that there is no other application of alternative remedy.
It page paragraph 38.
Paragraph 38.
And 381,
This one.
provision for appeal. So
4.2.
which one did he apply? He applied this 4.2.14.
Yes, sir. On 18/12/2023,
It takes some time. I don't think you'll finish. I think we'll have to do it some other day. We'll continue. Yes, all-
My general kind of the judgment, I will have to also take out the judgment. Only it's coming, suppression is something that happened prior to the final restriction, it is suppression. While filing the restriction, the appeal was not there. I will also see the order dated 5/1/124, the last line by the listener. Says liberty is pendency of the writ shall not be barred for the appellate authority to go ahead with the appeal. That was, but that was prior to filing of the affidavit. And the apex court has said that non-disclosure of the filing of the appeal of suit is not material to signing of opinion, that is not a suppression. And all the judgments which my London Fine is coming up, they are for rejection of the tender. That was challenged. Not after acceptance and blacklisting, nothing. That was at the stage of rejection of the tender.
Right. Dr. S. Saraf, Senior Counsel for the petition, assisted by Mr. P. Babu. Also heard Mr. S. Bhattakur, Learned Counsel for the respondents number 2 to 6. Next para, give para number. The petitioner has put to challenge the impugned order dated 8/23 issued by the BPCL. Bharat, what is that? Bharat
Corporation Limited.
Bharat Petroleum
Corporation Limited.
Corporation Limited, bracket BPCL. By which he has been blacklisted for a year by the respondent authority. The petitioner counsel submit that the facts of the case will show that the respondent authorities have blacklisted the petitioner due to a wrong assumption of fact. Some of which is to the effect that the petitioner would not have taken a decision. The petitioner had taken a decision that it would not supply. It would not make any supply beyond 12 crores of the pipe. Of what? Of the pipe. Of the pipe. Pursuant to the NIT dated NIT dated
16/8/22.
16/8/22, comma. Letter of acceptance dated 23/1/23. And first call off, CALLOFF. Call off it is separate. Slash purchase order dated 24/1/23. Correct? Those three, any other document? No.
That is the first NIT, letter of intent and the purchase order.
Correct. Any other document? No.
Thereafter, the dispatch order, that was.
Acha. No, and dispatch order dated 18/2/23. Yes, sir. The petitioner's counsel submit that an NIT dated NIT dated again, what is the date? 52.
I've just
NIT dated yes, what is the NIT date?
NIT first.
First 16/8/22, madam.
No, that is the due date.
इधर बना तो 2 1 6 1 6 मतलब 25 7 222
25,
7 122
22. For what?
the NIT date मतलब
No, what is the NIT for? Where is it written?
phase मतलब 52 मतलब
That much I got, but where is it? What is the
yes but
item to be supplied?
for procurement of polythene MD5 मतलब for PCL PGRL CGD product
Where are you reading? At for procurement of polythene bracket MDP bracket plus 5 for BPCL slash BGRL CGD projects. The petitioner's counsel submit that
Letter of intent, phase 216.
submit the
Letter of acceptance, phase 216.
the respondents number 2 to 6. Thereafter, issued a letter of acceptance dated 23/1/23 to the petitioner. Stating that its offer for the supply of for procurement of polythene pipe had been accepted for the total amount of rupees 15, 01, 70, 71. Thereafter, the BPCL issued a call of COLL, call of slash purchase order dated 24/1/2023 for procurement of polythene pipe for lot 1, 2, 3, and 4 of the tender as per the quantity given in the annexure B. Huh?
Value will be 5 crores,
Where is it at value?
but that is in page 17 of blacklisting order.
Huh?
In the blacklisting order,
Uh, we do not know. It's not stated here.
and mentioned in the petition also.
I don't know, but that is not here. That's the problem.
But in the blacklisting order, 12 crores 73, you're asking, right? That the total about it.
Uh,
Page 370.
what was it? For annexure B. Annexure B only gives the quantity
Value.
of the polythene pipes to be supplied and does not give the total value of the pipe to be supplied by the petitioner. Thereafter, the BPCL, then
Dispatch order, dispatch.
issued the dispatch clearance note dated 18/2/2023. To the petitioner. For the policy in five. In terms of annexure B of the call of letter dated 24/1/2023.
I mentioned the amount in para eight.
In,
I mentioned the amount in para eight.
though nothing is mentioned in the dispatch clearance note dated 18/2/2023, comma. The writ petitioner in para eight of the writ petition has stated that the value of the goods to be procured in terms of the call-off letter dated 24/1/23
Dispatch order.
and dispatch clearance note dated 18/2/2023 amounted to rupees
As per us, it was 11 crores 30 lakhs
11,
30, 097.
30,
My lord,
097.
my lord. And the second quantity you dispatch 550, 62, 300.
Huh?
The dispatch, dispatch order.
One is dispatch of 18/2/23.
Right.
Then which dispatch note are you talking? One is at page 282,
No, that is paid to 82, that is dispatch order.
dispatch order. Then that is the one.
My lord, this is amounting to 550, 62, 300.
But this is amounting to 552 only.
My lord,
But then you see one thing. When you come to page 230,
my lord,
just see the annexure B,
230, my
Yes.
lord,
231, annexure B.
my lord.
Now, when you see annexure B here, 231,
Right.
with the chart given in 282,
Right.
it is the same quantity.
No, this is 11 crores, no. This 12 crores, they are, according to them, it is 12 crores.
No, whatever.
Ah.
But you are saying 5 crores just now.
5 crores is the dispatch, no. Dispatch,
So you have dispatched only 5.
5, or dispatch
That's what.
order has been given to 5
Dispatch clearance has been given for,
crore 50 lakhs something.
no, dispatch clearance has been given for 11 crores.
No, my lord, this is purchase order, my lord.
This call off is only for 5.
My lord.
Huh?
Follow-up is for 12 crores, but dispatch order is also, you see the order, my lord.
No, one thing, you see, how can, one thing, you see, come to page 231.
231, sir. My lord. 231,
Now this 231,
my lord,
you see the quantity it's given.
my lord.
Now this according to you is how much?
This according to us is 11 crores something, according to them it is 12 crores.
Whatever, 11 or 12, let it be 11,
My
whatever.
My
So
lord,
231, according to you is 11 crores.
my lord.
Now when you see this quantity at 231, page 231, and you see the quantity at page 282,
Right.
it is the same quantity.
No, it's not same quantity. My lord, this is the dispatch clearance should be given only for getting 550, this is not the same quantity.
Okay, the dispatch is the top chart. You mean.
Dispatch is the top chart. And only,
And the lower is the reference to the earlier
my lord, earlier order was placed for this one, but dispatch clearance was only for part.
okay. come to the earlier paragraph, whatever. it is. That's the problem, unless we get the facts correct.
Fine.
That's the thing. Yes. Yes. First up. No, before that, before that. The, have we said that the amount is not mentioned? Huh? The cost of the cost of the procurement of polythene pipe, as provided in Annexure B to the call of letter dated 24/1/2023 has not been reflected. So, however, para 8 of the writ petition provides that, states that the call of slash procurement order dated 24/1/2023 amounts to rupees
11:30,
1130, 30,
30:09.
230, 09. Next para. Subsequent to thereafter, the thereafter the HPCL submitted a dispatch clearance note dated 18/2/2023 for an amount of how much?
550,
50,
62,300.
62, 300. Out of the procurement order reflected at Annexure B to the letter dated 24/1/2020. The next one, the petitioner, no, that's all I think. The petitioner's counsel subject that the HPCF has not made any dispatch order beyond the approximate 5.5 crore worth of pipe made in terms of the dispatch clearance note dated 18/2/2020. Till date. He submits that the petitioner has not made any statement or taken any decision to the effect that the petitioner cannot supply 15 crores worth of polythene pipe in terms of the letter of acceptance dated 23/1/23. On the other hand, the HPCF has only made a letter of acceptance dated 23/1/23 and taken delivery of pipe worth only approximately 5.5 crores. It submits that when the petitioner has been pressing the HPCL, the BPCL to take the remaining balance amount of polythene pipe in terms of the letter of acceptance dated 23/1/23. Huh?
As per the first follow-up letter.
As per the first follow-up letter dated 24/1/23. comma, the blacklisting of the petitioner on the assumption that he would not be supplying polythene pipe beyond the approximate value of 12 crores is without any bid. That's the case.
They are not saying beyond below, they are saying he will not supply worth 12 crore,
Okay, you will not supply 12 crores.
12 crore.
Okay. That you will not supply, what have I said? That's correct. No, it says, see, just come
Okay.
back, come back to that.
372 crore.
Okay.
Last but not least.
No, not on this. In the show cause notice,
Suppose notice we have said that. Suppose notice we have said. Suppose notice at page 368. The last 3 lines of the first paragraph.
okay, anyway, this is submission. So whatever I said. And the first call off. No, you will not be able to supply polythene pipe uh, amounting to rupees 12 crore. Amounting to, in terms of the first call off procurement order dated 24/1/23 is without any bid. Next para. So those are the facts of the case basically.
This is the
Next para. The petition council further submit that while the show cause notice dated 21/7/23 issued to the petitioner has stated that action could be taken against the petitioner in terms of clause 9 of the holiday listing policy of BPCL, comma. The impugned blacklisting order dated 8/2023 has not made a mention of clause 9 of the holiday listing policy of BPCL. He submits that the absence of the use of the word clause 9 no, cut that. Like, let's correct the level counsel for the level senior counsel for the petitioner. Further submit that with regard to the issue of whether this court has territorial jurisdiction to decide the present issue. Now, the show cause notice and the blacklisting order have been received by the petitioner in NSF. Further, his office and factory and place of origin for dispatch of goods would be assessed. as a part of the cause of action is within a SAP due to the reasons stated above, comma. This court has jurisdiction to try the presentation. In this regard, he has relied upon the judgment of the apex of the Supreme Court in SJS Business Enterprises bracket P Limited versus State of Bihar and others, 2004, 7 and
That was for suppress.
Huh?
That was for
Oh,
suppress.
that's a separate. Okay, State of Maharashtra and others. State of judgment of this court. Division bench of this court in State of Maharashtra and others versus State of Arunachal Pradesh and others, 2003, 2 GAU. What is GAU?
No, GLR, it will be mistake.
GLR. GLR 195. Bracket, you put para 2, comma 12. And in the case, and the judgment of the full bench, is it full bench, Gujarat? And the division bench of the Gujarat High Court at Ahmedabad, in the case of Ratnam Energy Private Limited versus Oil and Natural Gas Corporation Limited. R slash special civil application number 1235 slash 2021 bracket para 16. Next para. The learned senior counsel submit that with regard to the stand taken by the respondent counsel that there was suppression of material facts in the writ petition as no mention had been made by the petitioner that it had approached the HPCL authorities by way of an appeal under clause 4 point under clause
4.2.14
under clause 4.2.14
2.14
of the
holiday listing policy.
holiday
Policy for holiday listing of vendors in between.
this item. Of the
Policy for holiday listing
policy for holiday listing
of vendors
of vendors
in BPCL.
in BPC. It submits that
The appeal was filed after filing the petition.
it submits that the appeal was he submits that though the writ petition was filed, though the writ petition and the appeal was filed on the same day, comma, that is on 18/12/2023, comma, the appeal was filed after filing of the writ petition. He submits that the appeal filed by the petitioner was subsequently withdrawn on 14/2/2024. He also submits that The writ court has the power to call upon the parties to elect whether it can proceed. It wants to proceed with the alternative remedy or with an application under Article 2 to 6 of the Constitution. And further, the availability of an alternative writ of an alternative remedy is not a bar for this court to exercise its writ jurisdiction. So, in this regard, he has relied upon the judgment of the Supreme Court in the case of SJS Business Enterprises, bracket B, those limited, versus State of Bihar and others, 2004, 7 S 160. Next. Mr. P. Bhattacharya. Hi. S. Bhattacharya. I was looking at this. Mr. S. Bhattacharya. Learned counsel for the petition, respondent number 2 to 6, to submit that the service of notice upon the petitioner in his address in his stamp only gives him a right of action and no cause of action arises due to the setback. In this regard, he has relied upon the judgment of the Supreme Court in the case of
2013, 7
If you read this so much, I don't remember.
I think Kerala High Court judgment, Kerala High Court judgment, 2014.
Is relied upon the full bench judgment or what is it?
Yes, sir, it's a full bench judgment.
He has relied upon
2014 SCC online.
relied upon the full bench judgment of the Kerala High Court in the case of the registrar of Indian Maritime University East Coast Road versus Dr. K.G. Viswanathan and another, reported in 2014 STC online KER 21221. So we further submit that the writ petitioner in para 8, in para 38, in para 38 of the writ petition has given a false statement in as much as it is stated therein that there is, in what comma, there is no other efficacious and like or alternative remedy, and the remedy sought for by way of the instant petition is just, proper and adequate, is so granted. Put up inward comma. Correct? What other, you give me some other judgment. With regard to what? With regard-
Submit
huh?
online regarding court of action. 23 7 SCC 791.
Which one?
23 is other minutes, 23, 7 and 60.
Wow.
Yes, madam. It's regarding further better.
All right. What about separation? Separation, what we got?
Paragraph 13 of the madam, as their business in material
Oh, very good.
and madam, get it from.
Huh?
And get it from.
Okay, right. With regard to with the subject that has the petitioner has suppressed facts of and this court should decline to enter into the merits of the case and dismiss the writ petition. In terms of the judgment of the Supreme Court in the case of K.T. Sharma versus Steel Authority of India Limited and others, 2008, 12, 481. And para 13 of the judgment is SJS Business Enterprises Private Limited, P Limited. Supra. Then, with regard to what are
The cause of action, madam.
next para? With regard to the petitioner not having any cause of action to file the present case before this court, he has relied upon the judgment of the Supreme Court in the case of Goa,
Yes, madam.
the state of Goa versus Sumit Online Trade Solutions Private Limited and others. So, 2026, 7 SEC 79.
And madam, 1984.
Wait, bracket, para 2, 14 to 17 and comma 21. Comma, the next one.
1984, 4 SSC, 711. While in the
That was 1994. Oil and Natural Gas Commission. Oil and Natural Gas Commission versus Utpal Kumar Basu and others. 1994, 4 SPC 71. Bracket para 6, 7, 12, 14, 15. And what else?
12, 4, 6 SSC, 254.
Kusum Ingots and Alloys Limited versus Union of India and another 2004 6 STC 25 bracket para 6 to 18. Then what else?
The Mumbai judgment, the Nagpur bench judgment.
This is all on the same thing, same topic. How much did you give?
But in Mumbai is relevant, madam.
Huh?
The Nagpur bench judgment is
Okay.
the Kohli road line.
So he has also relied upon the Bombay High Court Nagpur bench decision in the case of Kohli Road Line, KOHLI, Road Line of Nagpur versus Maharashtra State Power Generation Company Limited from Mumbai. WP, their writ petition number 1577 of 2021. Decided on 16/3/26. Whereas it has held that mere fact that the office of the petitioner therein was situated at Nagpur was not sufficient to enable the writ petition to be filed at Nagpur for being entertained on merit.
Right, so to be with the
Full stop. Next one. Due to paucity of time, the matter is adjourned till Huh? we can try. No guarantee.
Can be
Okay. I've got that, day after tomorrow, I've got that full page. No, not the full page. Yeah. There are two full pages. One to read. Thank you. With there is no, this one is with, FKPT and.
Lordship, it is on the first.
Day after tomorrow, no, sir. Monday. Monday. Motion is very different. If it's Thursday, we've got a full page. Already next, and next Tuesday or Thursday, we've got another full page. And we've got some fixed items. That is it. My, what is. But that is that or something.
I think half an hour will be sufficient.
I don't know with the rate he's going, he's reading everything. It's about happening.
I'll set it on Mary shop.
How much?
Don't, yes, on merits only. No, you see, the problem is, now also I could have completed hearing you. But then on facts, I would have a problem dictating.
Gap of something already completed.
That's why I am writing this down so that next time I get an idea of what's happening. This is a matter on 12. 12? Or we want it earlier?
12.
7.
7 9. But 12 minutes.
12, I think. Well, actually, one thing is we are having problem all over India.
Yes, sir. That's why it's a certificate received. Very important for.
We can try on the 7th. We can try. We can.
7th, I'm not there.
Oh, 7th, you know.
That will be difficult.
Then 12th is the only time.
I have to understand that he finished with after I put in your food.
I don't know whether you'll take 15 minutes also. It goes. Sometimes it happens, no? People get so many things, new things come up.
New things also very good.
Anyway, so there's this pattern on 12th. Okay.
The pattern.
Okay.
So without making pattern, you'll also heard the interest matter. If interest subsidy matter, you'll also heard for 2 days.
Ah.
Now we went to different match, again we have to mention it.
Oh, that interest subsidy matter.
We could not mention pattern, so
Oh, that's why you went to a different page.
so today we mentioned before the other day.
I was thinking what happened to it. We had listed it,
It
no?
was to be listed today. It is listed some other time.
That's what actually today I was expecting that matter
All of that,
when I saw your name.
I know.
Anyway, leave this matter on 12th. As pattern. How do you matter? Huh? I've said pattern.
You can cancel to at 10:30.
At 2. At 2 better. Morning to difficult. Better. And you take the file, you want to type it out the further. No, we have got too many files. We've got that. What does this matter? Yeah. Okay, so you go and send someone. Give me either. What is the matter about? Give me the second file.
What if the matter is all matter is date of position lot and will pay lot from the date of position. From the date of position and regarding The date which he mentioned is the correct lot.
Just a minute.
So that's for tender.
Okay, so from that, 1st April to 7 July.
Yes.
That remission amount.
Yes, the remission ma'am, and my lord, that actual date of position of 8/7/2015.
Yes.
From then it'll have to be counted
Yes.
7 years.
Actually, he is supposed to, we have sanctioned 1 lakh rupees another. Right?
I have got, we have sent the,
We have sanctioned 1 lakhs more to them in the record. We were supposed to get one, he has not come. 2020.
oh,
My lord, we have already completed the step. Term has already been expired. So my lord, that regarding my lord, honest one.
Yeah, we are
they
supposed,
they will give everything,
we'll give everything.
give everything. So what about that 1 lakh you're supposed to give extra?
It is, the order is being made, but he has not come for that.
So now he can get rid of the order.
It's a BOD decision is also there, 1 lakhs 5,025.
So is it here in the records? No.
No, Lord, it is my record in the.
So should I incorporate that? No.
Oh, we'll pay. Now I'm saying it is a bonus for him, this 1 lakh.
That's why, why are you giving bonus?
Without delay.
You're getting good, you're getting some 10 kg fish or something.
Without coming to the court. Lord.
Okay, right. Heard Mr. A.K. Sharma, learned counsel for the petitioner. Also heard Mr. S. Sharma. P. Sharma. Learned counsel for
APC.
learned counsel for right. The petitioner hearing, you think this last order, 23/12/2015, huh? Take, para, second para, third para. Okay. Next para, the petitioner's counsel submit that in view of the above, in view of the fact that the petitioner has been handed possession of the fishery only on 8/7/2015, the lease period for the fishery should be till 7/7/2022.
No, but that is 31/3,
Huh?
31/3/2020.
31/3/22. 31/3/22. And no, forget that. Forget, don't cut that. This is already here. Cut that. So we start to increase there. The next para. Mr. P. Sharma, learned counsel for the AFDC submit that the respondent authorities have agreed to have agreed to the stand taken by the petitioner that he is entitled to remission of revenue for the period.
We have some obviously, without mentioning emission, but we pay the.
Is entitled to be paid. Is entitled to the return of some money. The return of some money amounting to rupees.
It will be from 1 April.
Return of some money from 1/4/2000 for the period from 1/4/2015 to 7/7/2015.
Yes.
Amount not required to be said.
Not required.
Good stuff. Accordingly, the proportionate amount of money required to be returned will be returned to the petitioner within a period of
Whenever he submits a certified copy of the report. Because I only.
as and when, not within, that's as and when the petitioner submits a
Certified copy of report.
certified copy of this document. That's all. In view of the consent of the parties, the writ petition is disposed of with a direction to the respondent authorities to pay to return to the petitioner the money payable for the period from 1/4/2015 to 7/7/2015 within 7 days from
After some.
within 2 months. No, within that 3 weeks. Within 3 weeks from the date of receipt of a certified copy.
If they wanting, then I place the record of that.
Okay. Whatever I said, that is, I have placed the record. No, before that. I have. No, just before review of the concept, it just recite, you just say, I have heard the learned counsel for the party and have perused the official record,
Here also it is stated.
comma, wherein,
Also it is stated 8/7 on 8/7/2015 year second.
wherein it shows that possession of the fishery was handed over to the petitioner only on 8/7/2015. So, as such, the petitioner is entitled to receive some money back from the response. Okay. And in view of the consent. Petition accordingly disposed.
2015 methodology.